everyone is doing well this early Wednesday, no matter where you are. We are currently streaming and broadcasting to YouTube and hold on one second. There we go. I think we are getting the bugs worked out here. Perfect. So we are broadcasting here to YouTube primarily, but as well Facebook and Twitter and LinkedIn. So no matter where you are, on what platform you're at, please please accept our thanks and welcome for joining us today. My name is Thomas Maddrey. I'm ASMP's General Counsel, Head of National Content and Education, and we are thrilled to have you as we talk about one of the biggest cases that has come along in quite a while. And we're going to have ample time to dive into a lot of the background of this case. But remember, what's going to happen here is for the next hour or so, we're going to chat about the case, the Andy Warhol Foundation versus Lynn Goldsmith. And then we're going to take a break and we're going to listen to the live oral arguments from the US Supreme Court. Now, the arguments are currently scheduled for about 70 minutes or so. And we're going to talk about what the different kind of process is and who you're going to be hearing from at that point. And then right after the arguments, we're going to be back here talking about the questions the justices asked and what that actually means and what we think about all that. As we get started here, I want to introduce Jeff Sedlick. Jeff Sedlick is a photography professor, photography expert, industry icon, and photographer himself. And I've had the opportunity to work with Jeff on so many projects throughout the years, and I'm so happy he's able to join us today because Jeff has some unique insight on this case, which I'm sure he'll mention here in a little bit. But Jeff, thank you so much for joining us, and why don't you just take a second and introduce yourself?
You bet. Thanks, Thomas. Thanks for inviting me. I'm a photographer and ASMP member, teach photography, and run a nonprofit coalition called the Plus Coalition, amongst other ventures.
Yeah. Well, Jeff, can you just here at the beginning give us a little background of your involvement in this case and when you first heard about this case?
Sure. Well, in addition to being a photographer, I've been involved in the trade associations for many years, all of the photography trade associations and others related to copyright. And in the course of that, I developed some expertise in copyright issues and legal issues affecting photographers. And when it came time for the litigation to proceed, when the Andy Warhol Foundation sued Lynn Goldsmith's attorney approached me and asked if I would serve as an expert witness at the district court level, not for Lynn Goldsmith, but retained by Lynn Goldsmith. Expert witnesses are neutral. They're not advocates for either side, even though I am a photographer, and even though I do know that the rights under discussion are important rights. My role was as a neutral expert to help the court to understand the various issues related to the license and the use and things like artist reference and things like that.
Well, I know that expertise is valuable not only for the courts but for us here as we talk about this case. And so let's start by talking about this case. You know, ASMP, if you are an ASMP member, you've certainly seen us talk about this case of Warhol versus Goldsmith. And part of the reason is that it's critically important. Another part of the reason is that Lynn Goldsmith has been an ASMP member for so many years. And we have stood by her and supported Lynn from the very first court case all the way up. And so let me just take a quick second and talk about how how the federal court system works. So originally, this case was heard at what we call the district court level. And we're going to get into how it got to the district court in a second, but I just want to go over a little bit of how the court system works here in the US. And in a district court case, that's the court that you often think of when you think of trial court or court on TV, right? This is where you might have a jury and you are presenting evidence and you're talking about the different facets of the case and all of the things that that you might commonly associate with court. But after the district court level, depending on which side prevails on the district court level, the other side, the side that didn't prevail, has an opportunity to appeal. And when they appeal to the next level up in the federal court system. And those are called the circuit courts of appeals. Now, in the US, there's a number of circuit courts of appeals, and they each cover a range of different states. So down here in Texas, I am in the Fifth Circuit Court of Appeals. That's where appeals would go if they were in the states that are covered by the Fifth Circuit, which include Louisiana and some others. Over where Jeff is in California, they're covered by the Ninth Circuit. And up in New York, where this case was heard, they're covered by the Second Circuit. So in this case, there was a ruling at the district court level. And before we get into that, Jeff, do you want to talk a little bit about kind of what led to there being a court case in the beginning and how it came to be that Lynn was actually sued by the Warhol Foundation? Can you talk about that?
Sure. So Lynn Goldsmith is a prominent, very experienced and respected photographer, and with a lifetime working in music and entertainment and related fields and shooting, advertising and fine art, music photography, very, very well known. And at a certain point in time, she saw that Prince Rogers Nelson, as he was then known, was coming up, and she went to Newsweek and said, you ought to do a feature on this person. And Newsweek said, great, we're hiring you to go ahead and do a feature. And so we'll arrange for the photo session. And the next thing you know, Lynn is shooting Prince. And Prince came to her studio, and she made a lot of creative decisions in figuring out how she was going to approach the session, as she does in all of her sessions, as we all do as photographers. And she began making photographs of Prince after directing his pose and the lighting and the background and his makeup and the wardrobe, etc. And as she was photographing him, he became uncomfortable just because of the nature of his personality, and he went and locked himself in his dressing room, or in the makeup room in her studio, and then ended up leaving after a while. And she got off very few shots. And she did, however, also photograph him live on stage for that session. And this was just for one-time editorial use. And I think that I happen to have that license here. If you'll just give me 1 second. Let's see. Newsweek. Let's see. I'll try and share my screen. We'll see if this works, Tom.
Great.
Just give me 1 sec.
No problem. So what we're going to be seeing is the actual license that was involved in this case.
Right.
Okay.
So here we go. Well, it's actually the initial license, not the license for Vanity Fair, but the license for when Lynn, it's very faint because it's back from the fax days, or pre-fax days, actually. But there are terms and conditions, there's pricing, it's marked paid. It's the original license from Lynn to make the photographs to Newsweek for one-time editorial use. And Lynn is a very buttoned up business person. She's a very successful business person. She operated a very successful stock photo agency called LGI. And her licenses are ideally worded licenses. The licenses that her stock photo agency or photo agency issued were also very well worded, as we'll see shortly. So Lynn went ahead and did this photo session. It was used in Newsweek, and then roll forward, I think it was 3 years or so, and Lynn was, or Prince had become quite famous by that time, and Lynn's photo agency was approached with a request for any photographs of Prince for an article to run in Vanity Fair. And these photographs were to be used for what's called artist reference, and that's a key point in this case. So artist reference is a commonplace license in the visual arts industry. An artist reference license typically entitles the licensee, the client, to be able to make a new work or a derivative work based on a photograph or some other visual art. And with respect to a photograph, that means an artist or photographer could make another photograph based on that. And the proper channel and method for that is to go and request the right to do that, buy or obtain an artist reference license, and then proceed under that license, following the limitations of that license, to make this new work. And usually there are restrictions in the license on the use of that new work, because the photographer who licensed it doesn't want to have to compete for their lifetime, the lifetime of the copyright, against a copy of their own work out there in the marketplace. And certainly that was the case here. And I'll bring that up again. So it was a very well worded license issued by Lynn Goldsmith's agency to Vanity Fair. Vanity Fair then took that license, and under that license, Vanity Fair then provided Lynn Goldsmith's photograph of Prince to Warhol. They did not inform, nor did they have to, Lynn Goldsmith's agency that Warhol was the artist who was going to create the photographs under the artist reference license. They properly licensed the photograph, and Lynn's license is very well worded. I'm going to see if I can zoom in to make it easier for viewers to see. So it's back in 1984, a fee for the use of one photograph of Prince, copyright 1981. So she's making sure that her copyright is communicated by Lynn Goldsmith for use as artist reference, which means you can make a new work based on that work, for an illustration that identifies the type of work that can be created, to be published in Vanity Fair November 1984 issue. So right there, she's locking it in to one-time use only in one issue of Vanity Fair. And you'll notice it says an illustration. That becomes important later. An illustration means one illustration. To be published in Vanity Fair November 1984. It can appear one time, full page, and one time under 1/4 page. No other usage rights granted. And as we go down, one-time use, English language only, North American distribution only. It's a pretty solid license. And this is the type of license you like to see, that's going to make sure that both the photographer and the licensee, the client, understand what they can and can't do with the work. And certainly, even if it had not been worded this well, Vanity Fair, being accustomed to buying artist reference licenses, and Lynn Goldsmith's agency, being accustomed to issuing them, would have understood what the license was for. But this is completely buttoned up. Then it says licenses granted to use, and then they crossed out or reproduce, because this is an artist reference license. It's not for technically for reproduction. It's to use it as artist reference, the above described photographs on the condition that the total is paid and that there's a credit line that must not be omitted, abbreviated, or altered in penalty of a double charge. So it goes on to have various terms and conditions here that further button it up, basically saying that it can't be used for any purpose other than the purpose described above, which is one issue, one illustration. So this is an ideal license for a photographer whose work has been infringed to be able to prove that only limited rights were licensed and that those were very specific. So
And
go ahead.
How important, Jeff, is the provisions that we see in there that talk about credit lines and usage? I mean, a lot of photographers know they need to have these type of licenses, but as you say, they're not always as buttoned up. So when the courts were looking at these various cases, how important did this license become?
Because the claim by the Andy Warhol Foundation is fair use. Well, in any event, this would have been an important license, but it is so buttoned up that they couldn't even get into whether or not the rights were communicated or what rights were communicated. And the case became not about confusion over what rights were granted, as many photography cases are, but whether or not Warhol had the right to create, which he eventually did, 16 illustrations based on this photograph, and whether or not the Andy Warhol Foundation and Warhol had the right to then license the more than one of those actually out to clients in exchange for license fees. So I think it's very important.
Go ahead. Yeah.
I do think that it's very important because it completely eliminated argumentation over what was licensed. And it really focused the case on the actual claim of Andy Warhol Foundation, which is they assert that it's fair use. And
we'll dive into fair use here in a second, but so just kind of recapping where we're at, we have this license, and Lynn's photograph was sent under this license to an artist who Lynn didn't know at the time, and everything up to that point, where this what Andy Warhol did to Lynn's photograph was created and sent to the magazine. That was all appropriate, right? That was all under an appropriately written artist reference license. And so, why is there any issue here, Jeff? What happened next?
Well, Andy Warhol's illustration ran in Vanity Fair with a credit to Andy Warhol and a credit to Lynn Goldsmith, and as is required under that license. And you have to remember that in 1984 or thereabouts, this was before the 1999 Berne Convention enactment here in the United States, before the United States went forward and actually enacted it. And what that means is, before March 1st of 1989, you had to have a credit line copyright notice on your work, or your work could fall into the public domain. And so that's where this requirement that her client provide her with that credit line is very important. And of course, there's a copyright notice on the publication satisfying the copyright notice requirement, but the credit that ran with the photo, adjacent to the photo in the gutter, was very important at the time. So right out of the gate, Andy Warhol violated the agreement, at least. Whether or not it's an infringement, we're going to we're going to hear from the Supreme Court eventually. And certainly the Second Circuit found that it was an infringement. But what happened at the time that the photograph, that the illustration was made, was Warhol created 16 illustrations, some silkscreens, some prints, so that was at a minimum a violation or a breach of the contract. But the interesting thing here is that the contract is between Lynn Goldsmith's company and Vanity Fair, not directly between Warhol and Goldsmith. But Vanity Fair did not have the right as a licensee to grant Warhol more rights than they received from Lynn Goldsmith. And so certainly Warhol would have seen the reproduction of his work full page in Vanity Fair with his credit and with Lynn Goldsmith's credit. Very prestigious publication. There's no doubt that Warhol saw that and was aware of Lynn Goldsmith at the time through that credit, if not also through the print that he received, which would have had her markings on the reverse.
So at the district court level, Lynn first went before the court case came about and talked to the Warhol Foundation, didn't she? Because at some point she learned that there was a second publication, right?
Right. So after initially, so first of all, Lynn was not aware of this license personally, or not intimately aware of it, because she was working photographer. She had her agency who was charged with handling the licensing of all of her works, and in the day-to-day activities, she would not have been immediately aware of that. And so she didn't see the original Vanity Fair issue that had this illustration by Warhol in it at the time. So you roll forward a number of years, a good number of years, and Prince unfortunately passes away. And at that time, Condé Nast, it's a parent company of Vanity Fair, wanted to run a picture of Prince in a special tribute issue, the type of issues that you see at the grocery store when somebody passes away that have just a whole bunch of photos from throughout their lifetime. And so they needed a picture of Prince. And instead of going to Lynn Goldsmith to license that picture, they went to ARS, which is the licensing arm, or let's say the licensing agency for the Andy Warhol Foundation. And they purchased a license to use the Warhol Foundation, the Warhol illustration, instead of the Prince, the Goldsmith photograph. Forgive me, I'm just on my coffee, and it's 6:30 in the morning here in Los Angeles, so might be speaking a little slowly today so far. So that's really the whole point.
Just so, go ahead. Yeah, go ahead.
That's really the whole point right there. An example of Lynn Goldsmith and Andy Warhol, or his foundation, competing to license the photograph or an image of Prince, and Warhol usurping or undermining or pulling the rug out from under Lynn's ability to license her photograph.
And so then, Lynn sees this and without, going into all the details, essentially says, hey, what is this? There was no photo credit. There was no license that was granted for this. Why is this work being used here so many years later without the license, without the credit, without the payment that was done previously, right? And the Warhol Foundation argued a few things, but But what they came down with, and what we're going to be talking about so much today, is essentially they said, well, you actually don't own the copyright in this, because we're going to sue you to prove that this is something that we now own, because it's been transformed under this idea of fair use. And so then a lawsuit ensued. And at the district court level, the district court found in favor of the Warhol Foundation, after an opinion which I certainly encourage people to read, because when Lynn appealed to the Second Circuit Court of Appeals, which may be the single most influential copyright circuit in the country, the Second Circuit Court of Appeals looked at that district court case and they said, no, that's not right. Lynn Goldsmith should have prevailed for these reasons. And it is an incredibly detailed and incredibly well-written opinion in the Second Circuit. And so now we have a case where the Warhol Foundation prevailed at the district court level, the very first level. It went up on appeal to the Second Circuit Court of Appeals, which is like the next level up in courts. And Lynn prevailed there after reviewing in detail this idea of what fair use is. And I'm gonna just take a second and stop sharing that for a second. But I'm going to take a second and talk about fair use, because fair use is something that is so often misunderstood by all creators, as well as those who use copyrighted works. And I think, without getting into all the details, which, if you're an ASMP member, you can hop over to the ASMP Academy and watch videos at incredible length on fair use, and I certainly encourage you to. But when we talk about fair use, we're talking about a defense to copyright infringement, right? Congress has set out that there are cases in which a copyrighted work can be used without the express consent of the copyright holder in certain events. Now, there's not any check boxes for what constitutes a fair use of a photograph, right? In the statute itself, in the law itself, you see things that talk about news reporting and commentary and criticism, right? These are items that are examples, but are not always examples. And what I mean by that is, there's no what we call bright line rule about something being fair use or not fair use. You know, as an attorney in private practice, I often heard from clients, and they would say, well, I'm an educational institution. I'm a nonprofit. So that means I can just take anything I find on the internet, right? And then it's fair use because, I'm a nonprofit. And the answer to that is clearly no, right? There is no singular category of things that is always going to be fair use, because the courts have determined that fair use is this holistic analysis that comprises these four factors. And so when the courts look at these four factors, they're looking at things like the purpose and character of the use, and the amount of the use in relation to the whole, and the potential on the markets of the use. These are some of the factors that we talk about. And so when the Second Circuit rendered their opinion in this case, after looking at this case, both at the district court level and then the briefs and information that were submitted in front of the Second Circuit, they determined that all four of the factors, all four fair use factors, weighed in Lynn's favor. And that what that meant is that the Warhol Foundation's argument that what Andy Warhol had created was a fair use of Lynn's photograph was actually not the case. that this was not a fair use of the underlying photograph. And again, as a reminder, certainly if you just came on board, this is really what we're talking about. As Jeff mentioned, on the left, you see a magazine cover that says "Special Commemorative Edition: The Genius of Prints," using the Warhol illustration, and on the right, you see the underlying photograph on which not only this illustration, but as Jeff mentioned, 15 others were based. Now, as a little twist in this case, right after the Second Circuit determined that this was not a fair use, there was a case heard at the US Supreme Court called Google versus Oracle. And Google versus Oracle is a case that focuses on software code and the copyrightability of software code and the nature of fair use in relation to software code. And you might think, well, why are we talking about that kind of case in this context? Well, I don't want to go too far down kind of a legal rabbit hole, but the Google versus Oracle case was the first time in 25 years that the US Supreme Court had heard a case related to fair use at the Supreme Court level. That case from 25 years previous was called Campbell versus Acuff Rose. This is a case about a song, right? Campbell versus Acuff Rose established so many of the rules that we've been working under for how to evaluate what fair use is. And it was Campbell versus Acuff Rose that and its progeny that came after, that the Second Circuit Court of Appeals used in analyzing whether or not this Goldsmith photo and Warhol's illustration of it was a fair use. But then Google versus Oracle came around, and the US Supreme Court came out and talked about this idea of software code. And the justices were very clear in Google versus Oracle that their opinion was focused on this idea of software code, right? It was a cabined opinion in a way that I think, and I'll just speak for myself here as someone who kind of watches these cases closely. I was hoping that the US Supreme Court would provide a little more clarity, right? Because clarity is something that we are always looking for, certainly in the field of fair use, which is a notorious gray area. So remember the situation. Lynn Goldsmith has won at the Second Circuit Court of Appeals. She has, the court has said, yes, all 4 fair use factors weigh in your favor. But then Google versus Oracle came out, and the Andy Warhol Foundation did something which isn't particularly common, not super rare, but not always common. And that is they filed for a motion for reconsideration based on the fact that the Supreme Court now has made up some new rules and has this new opinion in Google versus Oracle. So the Second Circuit Court of Appeals, and this is rare, they really don't often do this, granted the motion for reconsideration in part to look at this case again in light of Google versus Oracle to see, did that Google versus Oracle decision change anything that would have changed our opinion as the Second Circuit? And they came out, and there were phrases in the second time that the Second Circuit looked at this that, we emphatically disagree that Google versus Oracle had any effect on what we thought. And they reaffirmed their opinion that Lynn Goldsmith prevailed on all 4 fair use factors. So in fact, at the circuit level, Lynn Goldsmith won not once, but twice. There were 2 bites at the apple there, and both times the court found that all 4 fair use factors weighed in Lynn's favor. Now, when you're at the Circuit Court of Appeals level, and when you're at the Circuit Court of Appeals level, and you lose, you really only have one option. And that option is to apply for what we call a petition for writ at the US Supreme Court. And there are lots and lots and lots of cases that people apply to have the US Supreme Court hear. And there are very few cases that the US Supreme Court actually hears. And so when we saw that the Andy Warhol Foundation was filing a petition in the US Supreme Court to have them evaluate this case, and now again, I will only speak for my own opinion. Whenever I hear anyone applying to the US Supreme Court, you should almost always assume it's not going to be taken as a case. There are very few cases, percentage-wise, that are actually taken by the court. I also thought that it was rare that it was unlikely that the court would take this case for a few other reasons. One, the Second Circuit Court of Appeals had evaluated this case in light of the new opinion that came out in Google versus Oracle. So there wasn't a reason to not, there wasn't a reason for the Supreme Court to take it to enforce their new rule. The Second Circuit Court of Appeals had already incorporated that. The other thing that I thought made this rare is that, remember, I said it was 25 years ago that the US Supreme Court had last taken up a fair use copyright case, in that case, Campbell versus Acuff Rose. And then they took up Google versus Oracle 25 years later. But Google versus Oracle was just last term for the US Supreme Court, which means if the US Supreme Court took this case, the Andy Warhol Foundation versus Lynn Goldsmith, they will have now taken two cases about copyright fair use issues in 2 consecutive terms. Pretty rare, pretty rare. And so I was surprised that the court took this up for the reasons I just mentioned and a few others, but they did. And when the US Supreme Court takes up a case, it starts a whole host of things occurring. And one of the things I wanted to mention is what we call amicus briefing. And if you're familiar with ASMP, you're an ASMP member, you have often heard us talk about the amicus briefs that we write. And amicus briefs are briefs that are written. They can be written at any level of court, but normally at the Circuit Court of Appeals level or the US Supreme Court, where people from the outside who are not parties to the case come in and they write a brief explaining what would happen or what are the ramifications if a court were to determine one side or another on a given case. For ASMP, I often write amicus briefs that talk about copyright and how copyright laws should be implemented and how copyright affects working photographers and videographers and creatives and why it's so critical that these copyright protections are maintained. Now, in this case, I wrote a brief with Mickey and Alicia over at the National Press Photographers Association and Steve Doninger, who represents American Photographic Artists, APA. And we were joined, and so it was ASMP, NPPA, and APA joined by Getty Images, who read what we wrote and said, yeah, that sounds like an argument that is important and we want to be a part of. And so if you haven't seen what these briefs look like, I will share our screen real quick here. Let's see. So here, for example, is the brief of ASMP, and in this case that we submitted to the U.S. Circuit or to the U.S. Supreme Court. And if you just look at the table of contents here, oh, sorry, I didn't have it on. There we go. Let's try that. There's the brief that we're talking about. And if you just look at the table of contents, you can kind of get a sense of what our arguments were, where we talk about the plain language of the Copyright Act and the court's precedent require the Second Circuit's well-reasoned analysis to be affirmed. An overbroad definition of transformative threatens copyright as the engine of free expression. You know, I think the reason I'm bringing this up, and I'm about to bring up another amicus brief here in a moment, but let me scroll down for a quick second, because I want to get to what I think is a critical piece of this case. I'll make it a little bit bigger. You know, we started this argument with this idea of what's the use, right? What is the use that we're talking about when we talk about fair use? And I'm going to pass it over to Jeff, but you know, when we look at this, I want you to think, and when we're listening to the arguments today, I want you to think of this idea. In this case, an artistic portrait of Prince, as in the photograph created by Lynn Goldsmith, was used to create a derivative portrait of Prince. And both the original and the derivative were published on magazine covers after his death. The derivative didn't criticize, comment on, or even credit the original. It was not in any real sense a qualitatively different use. And in fact, it supplanted Goldsmith's original on the cover of Condé Nast. That is the core of the argument. Now, there are a lot of other reasons in the 32-page brief that I think are, I encourage you to go read. But there was another brief that was written, and Jeff, I would love for you to talk about this brief that we have here. Let's see where it went. There we go. And this is a brief, Jeff, that you wrote, isn't that right?
That's right. When you write amicus brief for the Supreme Court, you are required to work with a member of the Supreme Court bar. And I worked with a great attorney, Matthew Hirsch, who wrote the brief with me. Really, the brief is intended to be me speaking to the Supreme Court to make sure that they are aware of certain information that might not be obvious to someone who's not an artist and doesn't make their living based on licensing their work. And so I didn't even know that I could write an amicus brief because I had been the expert witness retained by Lynn Goldsmith, but a number of copyright scholars and others in the community contacted me and suggested that it was important that I do so. And so I took it up. And to be clear, my involvement with the case ended after I submitted my report and was deposed in the district court case. And that case went on to decision, and then I haven't been involved for many years. To give photographers an idea of how long that takes, I think, I'm not absolutely certain, but I think it was back in 2015 or 2016 that I began working on the case, and it proceeded all, and here we are in 2022. And that in itself will tell photographers that it's a long road, right? So there's no guarantee that you're going to win a case even if you're right. And in this case, Lynn was sued. She didn't even sue them, but it goes through the district court. That takes a few years, sometimes up to 5, 6, 7 years. Then through the appeals process, usually about 2 to 3 years. Then if you choose to take it to the Supreme Court and they accept what's called cert, as Tom mentioned, that's another period of time. So here we are in 2022, and this very important case has reached the pinnacle of the legal system in the United States. And it's an absolutely critical case that will in some measure determine whether or not creators can make a living or have an incentive to create new works. If we all create works and anyone can just take them and make use of them and adapt them and merely claim that they added new meaning to it, and be able to then freely use our works, what incentive do we have to create new works? And this does come back to really the core issue here, which is called transformative use. And if you take that back to its significant root, there's a very famous and respected judge named Judge Laval. And back in 1990, I think it was, he wrote an article for a Harvard Review in which he described what was called transformative use. And I have a quote here. And in his article, it was the 1990 Harvard Law Review. The question that he addressed was whether a secondary work, meaning a copy of a work or a derivative work made based on a photograph or other work, adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. It asks, in other words, whether and to what extent the new work is transformative. This article has been broadly misinterpreted, and Judge Laval has come back on several occasions to try and clarify what he actually meant there because of the broad misinterpretation. Because what it's resulted in here 30 years later is anyone can feel, let's say the people who would take a work and make a new work based off of it, and they end up in court, they will always say, I changed, I added this meaning and I added that meaning. Even, looking directly at the Warhol copies, you can see, looking at that silkscreen, what Warhol did, and it's actually been described in the case through testimony, was to make a silkscreen. You take the photograph, you put it in a camera, you photograph it, you make a high contrast copy, then you make a screen from that and you screen it onto whatever the substrate is, right? So it is a copy of the photograph laid down using a different method than strict photography, still using photography in a way because you burn this image into a material that you then make the silkscreen from. So then he overlaid some various colors out of register, and even Warhol himself never talked about meaning or message, which is the core of this Supreme Court case right now. He never said anything other than he was in the business of making art, and art is business and business is art. Basically, I'm paraphrasing there. But it is the scholars and others who are imbuing new meaning and message into Warhol's work that he never actually described here. And every photographer who is up against a fair use claim runs into this transformative use claim. I have to say, fair use is very important to achieve balanced copyright law. And ASMP is not anti-fair use. I'm not anti-fair use. Fair use is absolutely essential, but the purpose of that exception to copyright law was to allow others to comment on our work, not to use our work to make other statements unrelated to our work. In other words, fair use would be to criticize Lynn Goldsmith's portrait of Prince, to review Lynn Goldsmith's portrait of Prince, to teach about how Lynn made that portrait of Prince and the story behind it, to make fun of or to parody Lynn Goldsmith's photograph. Not to take Lynn Goldsmith's photograph and then make new works on it that compete with Lynn Goldsmith's work and don't comment on Lynn Goldsmith's work in any way. They're really about Prince himself. And then take that and license it throughout the copyright life of those silk screens in competition with Lynn. And that is the question that's before the Supreme Court today, which I'll read and then I'll turn it back over to Tom. It's not the whole case being retried here by the Supreme Court. When the Supreme Court wants to listen to or consider some aspect of a case, it's limited to the question. And the question here is, quote, whether a work of art is transformative when it conveys a different meaning or message from its source material, as this court, the Ninth Circuit, and other Court of Appeals have held, or whether a court is forbidden from considering the meaning of the accused work where it recognizably derives from its source material, as the Second Circuit has held. And I'll just mention before I turn it back over that the creation of a derivative work is one of the core exclusive rights in copyright law that creators such as photographers have. It's called the right to adapt your work. To adapt your work by creating new and different works from your work. And in order to do that, you must have a license from the copyright holder. And it's a core right. And without that right, anyone could make adaptations of your work without your permission. And this is the most important Supreme Court case or court case, period, to photographers this century, last century. There's nothing going all the way back. There are cases that have been important. This is it.
Yeah, I couldn't agree more, Jeff, about the importance of this case. No matter which way the court rules here, it's going to have a significant impact on photographers, a significant impact on copyright holders, a significant impact on those who use the works of copyright holders in all forms and fashions. And if you look through the arguments, I mentioned the briefs that Jeff wrote and I wrote for this case in support of the position that Lynn raised. There are a number of briefs written by others in support of a different view, a view that in many cases would expand fair use fair use law in a way that would dilute and to certain extreme examples that we see out there, seek to almost eliminate the rights that are granted from Title 17 in U.S. copyright law. What we're going to do here, because we are coming up to the top of the hour, and at the top of the hour is when oral arguments are going to be held in this case. Now, I want to mention a few interesting things that have occurred in this matter. And I'm going to ask Jeff one last question here at the end. But let me talk about the format and the process. A U.S. Supreme Court case is not like you see in Law and Order. All it is the 9 justices, including Justice Brown Jackson, who this I think is the first. This is certainly the first copyright case that she's heard as a sitting justice. That they have an opportunity to listen to arguments from the lawyers for the parties, and then they have a set period of time to ask questions to the attorneys about this case. And their questions are usually very revealing and interesting. But let me caution you at the outset to not read into what we think the outcome of a case might be based on the questions that are asked by the justices. In so many cases, we see as a line of questions that would seem that one justice is leaning one way, only to have the opinion come out and that justice was just trying to really determine the contours of the argument. There isn't going to be a decision raised today or rendered today. It's going to be many months before we see the final opinion come out from the U.S. Supreme Court. But this will be the last opportunity that the two parties have in presenting their arguments to the court about the nature of fair use, specifically the nature of transformative use, and what does it mean to be transformative. And if the court finds that the work that Warhol created is a transformative use, that means that Lynn doesn't win this case, right? Because what they're saying is this work has been deemed to be a fair use, and as such, it is its own unique entity. It's its own thing. Now, if the court says, you know what, the process that Jeff just described, the process to get from Lynn Goldsmith's photograph to the illustration that we saw is not transformative, which of course is the argument that we made and in our brief and many others made, and for a variety of reasons. then what that means is that the court has held that the Second Circuit's opinion, where all the fair use factors weighed in Lynn's favor, will be the opinion that carries the day. Now, there are some other options that could happen in the final opinion, but what's going to happen is you're going to hear from the lawyers for the Warhol Foundation for a period of time, 20 minutes, I think. Then you're going to hear from Lynn Goldsmith's attorneys. The Warhol Foundation lawyers are going to have a chance to provide rebuttal if they wish. They don't have to. There's ways you can carve up time. But then here's the last piece, and this is an interesting twist. Right before the briefing deadline, the U.S. Copyright Office, through the Solicitor General, decided they would weigh in on this case, and they submitted a brief. So the United States of America has submitted a brief in this case. And by and large, that brief is supportive of Lynn's position. There are areas where the brief differs from all the arguments that Lynn has laid out, and certainly the reasons behind the arguments. But at the end of the day, the Supreme Court did weigh in, or the U.S. Copyright Office did weigh in. So we're going to have an opportunity to hear from the Solicitor General today. And the Solicitor General is going to be relaying an argument to the U.S. Supreme Court about this case as well. Now, this is happening in just a few minutes. We are going to shut off our cameras. I am going to try to share the tab where the live oral argument is and the audio so that you can hear it, but I'm not promising that will work. What I will promise, and I will show you this here, is that you can go to the U.S. Supreme Court website, and this is where you can listen to live oral arguments. And probably the easiest way to get directly to this page is just to type into Google live argument U.S. Supreme Court, and it will take you to this page right here. Once the arguments start, this page will go live, and you'll be able to hear the audio. You won't be able to hear video, or you won't be able to see video. The U.S. Supreme Court does not have video feeds. It only has live audio feeds. I am going to be listening. Jeff is going to be listening. Others are going to be listening to these arguments. And right after the arguments end, and there's been, I think, 70 minutes allotted for this argument. So that means for all the different sides to go back and forth and the Solicitor General to talk. Once that ends, we will be back here. So at that point, you can meet us back here. I'm going to shut off our cameras for the moment. And Jeff, I look forward to checking back in with you here in about 70 minutes time, if that sounds good to you.
Absolutely. Thanks a lot, Thomas.
Thank you.
We will hear argument first this morning in case number 21-869, Andy Warhol Foundation versus Goldsmith. Mr. Martinez.
Mr. Chief Justice, and may it please the court. Both courts below agreed, and Goldsmith doesn't dispute, that Warhol's print series can reasonably be perceived to convey a fundamentally different meaning or message from Goldsmith's photograph. The question in this case is whether that different meaning or message should play a role, any role, in the fair use analysis. Our answer is yes. Warhol's transformative meaning puts points on the board under factor 1 of the 4-factor balancing test. Goldsmith and the Second Circuit say no. Warhol's new meaning is categorically irrelevant and can't be considered as part of factor 1 or any other factor. I want to emphasize 3 points. First, the precedent supports us. Campbell unambiguously requires an examination of meaning or message. Google reaffirms that test and cites Warhol's soup cans as a paradigmatic example of when it's satisfied. Goldsmith's test is at odds with both cases. Second, our approach, unlike Goldsmith's, maintains a balance between protecting artists' rights to monetize their works and encouraging new and important follow-on expression. We give follow-on artists credit for innovation at factor 1, while recognizing that factor 4 and the other factors will sometimes cut decisively the other way. Goldsmith's necessity test, by contrast, upends that balance. It banishes transformative meaning from the equation altogether, and by doing so, it violates 107's text, contradicts precedent, and undermines copyright's key goal, promoting creativity for the public good. Finally, the stakes for artistic expression in this case are high. A ruling for Goldsmith would strip protection not just from the print series, but from countless works of modern and contemporary art. It would make it illegal for artists, museums, galleries, and collectors to display, sell, profit from, maybe even possess a significant quantity of works. It would also chill the creation of new art by established and up-and-coming artists alike. These results are repugnant to copyright and to the First Amendment. You should reject them. We ask you to reaffirm Campbell and reverse the decision below.
Could you give us an example of any follow-on work that fails your test?
Sure. I think a classic example would be a book-to-movie adaptation. I think that would be a follow-on work. It would be a derivative work. I think if someone were to try to do that, I think that the original creator, the author of the book, could very easily assert that that was not fair use and would have a winning case under factor 4 and probably also under factor 1, and certainly that would be a kind of classic example of a follow-on work that would not count.
Why? I mean, derivative works are generally in a different medium, and almost all of them, even a dramatization on theater or even a motion picture or a sequel, they add something new according to your definition in your brief. So why shouldn't they be protected as well, according to your theory?
Yeah, I think there's a factor 4 issue and a factor 1 issue. I think the most obvious problem would be a factor 4 problem for the person who's trying to copy or create the movie adaptation.
I'm sorry, I read factor 1. The purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. So what's the use here? I think I have to look at a use under 1 as well. So is the use the creation of the print series by Warhol? Is it the 2016 license of the Orange Prince? That factor, I think, is telling to me to look at a use. So which use are you looking at?
So we think that both uses are directly implicated in this case. I know there's a significant amount of confusion between our side and the other side on this, so I'd like to try to clarify it. This case came about because Ms. Goldsmith contacted the foundation, asserted that the original Warhol works were infringing, demanded a quite substantial 7-figure sum of money, and also demanded the copyrights in the work.
I'm putting that aside.
Sure.
Okay? They can tell us whether they're claiming, I think they're out of the statute of limitations, so they can't claim that. So I think the only thing they can claim under the statute is the 2016 license.
No, respectfully, Your Honor, that's not right, because what they claimed in their complaint, and this is at JA 120 to 121, was that they said that we were not allowed to invoke our copyright in the works. And that wasn't just a past question that's sort of like water under the bridge because of the statute of limitations. That has ongoing significance because
All right,
if we...
so then I want to break them down. Assume that it's the creation. I understand your argument. It was a painting. It was a comment on consumerism. If that's all he did, that's one thing. But let's look at the 2016 license of Orange Prince, which is what I thought this case was about. But putting that aside, assume it's that.
Okay, assuming that we're just talking about that piece of the case, the licensing use.
Right.
Even with respect to the licensing use, you'd still need to look at factor one, which would look at the purpose and character of the use. And that would certainly encompass the fact that Warhol's use, the image that's being licensed, was transformative and infused a new meaning or message on top of Goldsmith's original work.
That I spot you. It should be considered.
Well,
The Second Circuit didn't. But then what do I do with the rest of factor one? The purpose and use and character of the use. Because that's not just up to the author, that's up to what use was made of Orange Prince. It was a highly commercial use. Goldsmith also licensed her photographs to magazines, just as Warhol's estate did. So how is it that your 2006 license and Goldsmith's photographs do not share the same commercial purpose?
Well, I think that it's true that that there is a commercial purpose, and so that might be a factor that would cut against us when assessing factor one. We think that the quite substantial and this, in our view, undisputed transformation in meaning or message
Yeah, but
would
for
trump
that, don't we have to look at the context of the use?
I think you would look at all the factors, but again, Your Honor, I think your point, it's not a small point to say that the Second Circuit got this wrong by banishing transformative meaning or message. That's
Assume
a
that
huge
it got
deal.
it wrong. The question is,
How would we still win?
I thought your brief was arguing, and you seem to be arguing something different today, that the transformation standing alone gives you factor one.
Right.
And I don't see how that can be.
Your Honor, I think let me clarify our position. Our position is that factor one has to encompass the new meaning or message. We do not deny that there are other considerations that may bear on factor one. We think the district court below correctly recognized that the transformative meaning or message was so significant here that would mean that we win under factor one, and in fact, you know, for the other reasons under the other factors that we also win the whole case. If you disagreed with us on that, I think what you could do is make very clear that the Second Circuit's banishment of meaning or message from the inquiry was wrong. You could send it back down to them. I think you should say that the transformation of meaning or message here was substantial, but if you thought that other factors had to be weighed, you could send it back down to the district court or the Second Circuit to reweigh those.
Mr. Martinez, let's suppose that, and I think you can do this with technology, instead of the mood that Prince is conveying in the Goldsmith photograph, you put a smile on his face and say this is a new message. The message is Prince can be happy, Prince should be happy. Is that enough of a transformation? The message is different.
I think you would certainly have to consider the new meaning or message as part of the inquiry. And so if the question is whether that would be like categorically irrelevant, the answer is no, and I think the Second Circuit would not even consider it, and therefore the Second Circuit's wrong. I think, though, Your Honor, you're sort of suggesting, I think correctly, that there might be different degrees in transformation that might make a difference in the analysis. We would agree with that.
No, what I guess I'm trying to suggest is that there may be nothing left to the original author for derivative works. I mean, if that's not a derivative work, it's hard to see what would be.
Well, I think I think you would do two things. First, at factor one, you would have to look at the degree of transformation and meaning or message. I think that wouldn't be dispositive of the fair use question as a whole, though, because I think you would then look at factor four, and you would really have to look at whether the market for the new work is in a real substantial way is going to be a market substitute or compete with either the original work or the potential derivative uses of the original work by the original author. So we think we're not denying that factor four is relevant here. We're just saying that for purposes of factor one, you certainly wouldn't ignore the transformative meaning or message for purposes of that factor. It just needs to be considered as part of a holistic analysis.
Can I take you back, Mr. Martinez, to your answer to Justice Thomas's question? Because you said, well, the classic example of non-transformative work would be a movie from a book. And indeed, we expect Hollywood, when it takes a book and makes a movie, to pay the author of the book. But I think movie makers might be surprised by the notion that what they do can't be fundamentally transformative. I mean, mostly movies are tons of new dialogue, sometimes new plot points, new settings, new characters, new themes, you would think, new meaning and message. So why is it that we, can't imagine that Hollywood could just take a book and make a movie out of it without paying?
First of all, I certainly agree with your bottom line conclusion that you can't just take a book and make a movie out of it. I think the question is, how do you get there, and how do the different factors play in? We think two factors are relevant. Factor 1, factor 4. The other factor is probably also relevant, but the factor 1 and 4 may be the most relevant. With respect to factor 1, we would say that the normal sort of book to movie transition, we don't think that the necessary sort of changes in the form from the written word into a movie, that would inherently be a change in meaning or message. And we think actually in most cases the change from a book to a movie wouldn't have a different meaning or message, or if it did, it would be very slight. I think the more fundamental reason, though, why the book-to-movie adaptation would not be fair use is factor 4. Because the classic thing, if you're an author, a successful author, the most natural derivative market, the derivative use of your work and the potential market for your work, you sell 1 million copies of your book, the next thing you want to do is make the movie based on the book. That's like the classic thing you would do. And so, of course, if someone comes in and makes the movie, a year before you make it, that would be interfering with the market for your, potential market.
Isn't the classic thing with a photograph that it'll be used in stories about the subject of the photograph, and therefore competing in the same market that this adaptation was used in? Namely, it was used in a story about Prince, not a story about Warhol. And at least from the perspective of the other side and some of the amicus briefs, that's the key distinction here.
I don't think so, Your Honor. I don't think, and I think the Second Circuit actually agreed with us on this. They said that the primary work itself would not actually compete as a market substitute with Goldsmith's photograph, and I think that's exactly right. I don't think that the standard use of Goldsmith's work would be to create, Warhol-style transformed celebrity, fine art portraits in the way that Warhol did. And I think in any event, if you had concerns about that, it's really a factor 4.
I mean, I guess this goes to the use, but it's being used in a story about Prince, just like the '84 story in Vanity Fair.
You mean the story like the Vanity Fair article?
Mm-hmm.
I guess what I would say is that if you think that that's a competing sort of substitute, that's a factor 4 inquiry. I think that the court below recognized that the Warhol work did not compete as a market substitute at factor 4 with the Goldsmith photograph, and this is really a factor 1 case. Yes,
sorry, can I have you focused in on factor 1? Because I sort of thought that that's really what we were focused on here. And you continued to say that meaning and message, you think the problem with the Second Circuit is that they banished meaning and message from that factor. I understand that, but it doesn't help me to understand how you use or you purport to use meaning and message in the context of the purpose or character inquiry in factor 1. So I could see, for example, as we evaluate the purpose and character of the use, that you might say, well, this is a new purpose insofar as our purpose was to provide a new meaning and message. So it's sort of embedded in the consideration of purpose, or this has a new character because it conveys a new meaning and message. Is that how you're doing this? I didn't see you filtering meaning and message through purpose and character.
Thank you, and thank you for focusing on the text. Let's talk about the text. The text talks about purpose and character. I don't think there's any real dispute about what those words mean. We think that the transformative meaning or message directly affects both purpose and character. So let me just take them one at a time. With respect to purpose, we're talking about visual art, and visual art is intended to be seen by audiences. A major purpose of visual artists is to communicate through their work, when they put the work in front of the audience, certain meanings or messages to that audience.
Can I just stop you for a second? Are you just sort of hypothesizing about that, or are you saying that was actually the purpose of this use in this situation? Because anybody could sort of say after the fact, oh, a purpose of visual art is X. I thought this was about the purpose of the use in this particular case.
I don't think it's disputed, and I think it's common sense that artists like Warhol intended their works to be seen and were intending to communicate, messages through their works.
So it wasn't the purpose of this particular use to illustrate the Vanity Fair article, and this is where the commercial part comes in. That wasn't the purpose?
That was part of the purpose if you look at it at a higher level of generality. We're not saying that's irrelevant, but I think even when you look at the actual article it was illustrating an article entitled Purple Fame that was all about Prince's emerging celebrity iconic status. And so it's perfectly natural to illustrate that article that you would want a Warhol type work that has as its meaning or message a picture of Prince that shows him as the exemplar of sort of the dehumanizing effects of celebrity culture in America. But just to go back to the, oh, sorry.
No, go ahead, finish.
Just to go on the text, so I do think that a new meaning or message necessarily changes the purpose of the original work. As to character, just briefly, character just means a quality, trait, or attribute. And certainly if the message of the work changes, that would be a quality, trait, or attribute of the work. And I think the problem with Goldsmith's side is that they're essentially arguing that a new meaning or message has nothing to do with purpose, doesn't change the character of the work, and it's just the only level of generality you can look at those things is at the level of, well, they're both portraits of Prince, they must be the same. And I don't think that's a common sense or appropriate way to look at this. Sorry, just...
How is a court to determine the purpose or meaning, the message or meaning of works of art like a photograph or a painting? Should it receive testimony by the photographer and the artist? Do you call art critics as experts? How does the court go about doing this?
So, Justice Alito, I think that the short answer is I think the court can do it in exactly the same way that this court and the lower courts did in the Campbell case. So in the Campbell case, the issue was parody, but one of the issues in the case was whether the Two Live Crew song was in fact a parody. And in order to do that, the court needed to assess what the meaning or message of the work was. And Justice Souter, in his opinion for the court at page 583, he sort of does his own analysis. So I think you could just look at the two works and figure out what you think as a judge. But I think that more likely in most of these cases, the way that they've been litigated for almost 40 years, the litigants would put forward, in addition to the works themselves, put forward evidence. Sometimes it's evidence from the creator, both creators. Sometimes it's expert evidence. Sometimes it's other kinds of evidence. But that's sort of like the standard run-of-the-mill way that litigants in these copyright cases try to argue about and establish meaning or message, and we think that's totally appropriate in this circumstance.
You make it sound simple, but maybe it's not so simple, at least in some cases, to determine what is the meaning or the message of a work of art. There can be a lot of dispute about what the meaning or the message is. Some people would say it's not necessarily the meaning or the message that the artist had in mind. I don't know, if you called Andy Warhol as a witness, what would he say was the purpose of the message or meaning of his
I wish
creation?
I could answer that question. He's not with us, as you know, Your Honor.
I know that.
But I will say this about the problem that you've pointed to, which is a real concern. I understand why it's a real problem. I think that the answer to that problem is solved by Campbell, because Campbell does not say that the court or the fact finder needs to figure out the meaning or message. It says it needs to figure out whether a new meaning or message could reasonably be perceived. And that creates a bit of a latitude of sort of a wiggle room that defers to the fact that there might indeed be, a bunch of different reasonable interpretations
of art.
You say
in your reply brief that the new thing has to be important, correct?
That's taking that from Google, new and important.
And
yes.
and how do you go about thinking about what's important in the follow-on work?
I think in the context of copyright law, you would look at important in light of the objectives of copyright law. And here it's promoting creativity for the public good. And so you would look at that just the same way that Judge LaValle talked about in his decision, and I think the way that both the Campbell and Google courts did. And what Google said, right after it said—
that doesn't give me a lot of specificity. I understand that we're supposed to be encouraging creativity, but what's the difference in the follow-on work that when we look at it, we can say, well, that's an important difference that does something that we really need to hear or to see?
So what the court said in Campbell was it equated the new or important inquiry with a serious inquiry into transformative meaning or message. And when Campbell uses that language, new and important, it's immediately following the sentence where it's quoting, when Google uses that phrase, it's immediately following the place where it quotes the language in Google, in Campbell, that says new meaning or message, count.
Counsel, going back to your answer to Justice Kavanaugh and now to Justice Kagan, what's the right level of generality? You keep going back to the author's purpose, and I can't stay there because when I look at Harper and Row, we define the purpose of the use as news reporting. In Campbell, we repeatedly refer to the use as its parody character. In Google, we talked about creating a new product that does something different. That's a fairly high level of generality, and that's the level we talked of.
Well,
I don't know why the level that we talk about here is the actual use, which is what Section 1 tells us to do, of this piece of art. And we go back to Justice Kavanaugh's point. The specific use was of this one part of the Prince series, only one level of it, as a photograph in the life of Prince. Now, that use, you say on factor 4 that it doesn't compete with the photograph, Goldsmith's photograph, but hard to see how not. They both sell photographs to magazines, and they both sell photographs to magazines to display Prince's vision or Prince's look. So I guess I go back to my point, which is why isn't the higher level of generality what Section 1 is looking at?
Your Honor, I don't think that that's what Section 1 is getting at, but I think Campbell makes that absolutely clear, because if it were the case that you had to look at the higher level of generality, in Campbell what you would have said is you have a Roy Orbison song that's a work of popular music that's commenting on sexual attraction, and you have a Two Live Crew song that's also a work of popular music, also commenting on sexual attraction. They would have the same purpose, but you didn't do that. Instead, you said, we need to look at the meaning or message, and then you analyzed whether the second work had a different meaning or message because it was commenting on the first. So you had to do that analysis, and I actually think Goldsmith's test actually requires you to do that analysis. They're not asking you to overturn the parody case law. What they're asking you to say is that the only meaning or message that can possibly ever count as a difference in meaning or message is when you have a parody. But that's arbitrary.
I don't think that's true. I mean, I think that the one thing that Campbell pointed out is that Two Live Crew couldn't have parodied, and this would also apply to commenting on, this would also apply to critiquing maybe in the way that Warhol's Campbell Soup painting does, but that you needed the object. You didn't need, or Warhol didn't need Goldsmith's particular photo, right? I mean, it could have been a different photo.
Well, what Goldsmith said below is that he did need the photo, and I think that's reflected in the district court opinion. But I think just stepping back from the question of need, I think that it's true that in parody there might be an especially strong need to quote from the work that you're critiquing, but that doesn't mean that that's a requirement of transformative meaning or message. And as Your Honor pointed out, when Google invokes the soup cans hypothetical, the soup cans, if you're issuing a comment on consumerism, you don't need to use, a copyrighted Campbell soup can logo in order to make that comment.
But you could use Cheerios. I mean, you'd have to use, it doesn't,
you could find
it just doesn't have the same punch
copyright
if it's generic. Well, okay.
But I think the soup cans example is especially helpful on that point, because it doesn't look for some sort of need or justification. Neither party sort of argued, and the courts below didn't assess a necessity test. I understand Goldsmith at this stage in the case to be introducing for the first time a kind of indispensability requirement, which has really no footing in any of the court's case law and really wouldn't make a lot of sense. Certainly the soup cans example, it was not indispensable for Warhol to use the Campbell soup logo in order to create that image, and yet the court itself recognized that was a paradigmatic example of fair use.
You said something a minute ago about commenting on the original being a key feature, and I think that's true with the examples listed in the statutory text as well, where they're commenting on the original. And I think the import of Campbell is that parody is a comment on the original in some respects. But how is a photograph used in an article about Prince commenting in any way on the original photograph. You might say that's the wrong way to look at it, probably, but if that's what you're going to say, tell me why.
Can I just answer your point about the text? Because I think that the text does not actually require commenting or criticizing the original. It just says comment or criticism. And so there's nothing textually that requires the comment actually to be the original. I think the better way to understand the text is if you look at Justice Blackmun's dissent in the Sony case, not a point that was, this point was not, what he was dissenting on, but he was describing those different uses, and what he said is that they're all productive uses. And that was the term that was used at that time to talk about the sort of transformative uses that we're talking about
If you
now.
go to Campbell, the part of Campbell right before the part that you quoted says the central purpose of this investigation is to see, in Justice Story's words, whether the new work merely supersedes the objects of the original creation or instead adds something new.
Exactly. And so I think what supersedes is doing there is it's set up as it's juxtaposed as the opposite of what comes after the instead clause. And what the instead clause is new meaning or message. And so I think what it's recognizing is that the superseding that Justice Story is worried about is when you don't have a new meaning or message.
Go back to the question I asked about when a photograph's used in a...
Is it commenting on the original?
In a story about the subject of the photograph, how is that not superseding the object of the original photograph?
So it's not, because it has a transformative meaning or message. It would have sent a different message to use the Goldsmith photograph illustrating that Purple Fame article. The Purple Fame picture, the picture that accompanied that article, was intended to, or did show its meaning or message was about the dehumanizing effects of celebrity as applied to Prince. The Goldsmith photograph, as she herself said below, this is at JA 490, around 496, she was testifying as to what she was capturing. It was a photorealistic portrait of Prince that showed him as fragile and vulnerable. There's no real dispute in this case that the meaning or message of the two works were different. The only real question in this case is whether that difference matters. And it has to matter both because of the text of 107, which talks about purpose and character, and
Does it matter, though, how the new photograph, the Warhol photograph, is used? It's used in a magazine article about Prince. That would be one thing. It's used in a museum setting. That might be something very different, because the Goldsmith photograph competes with the Warhol in the first.
I think if you're talking about a particular use, absolutely it would matter for factor 4. I think it would also potentially matter as to factor 1, but it wouldn't cancel out the fact that you would have to consider transformative meaning or message. I just want to emphasize, though, and this is a very important point, this case really is not about just the licensing use. This case is about the creation. If you look at the request, her request for relief and our request for relief in the original complaints, this was a dispute over who owns the copyright to these works. She was asking for an injunction from us that would prevent us not just from licensing the 2016 work. She wanted an injunction that would prevent us from reproducing, displaying, selling, or licensing those works. The order that we won from the district court was an order that, as a matter of law, summary judgment, fair use as to all 16 works. She didn't dispute that. In fact, she proposed the order that the district court ultimately issued. So this case is not just about the use, it's about the creation. And the reason that she wants to change the subject and make it only about the creation, about the licensing use, is because she realizes that if this case is about use, about the creation of the works, then it would have dramatic spillover consequences, not just for the Prince series, but for all sorts of works of modern art that incorporate pre-existing images and use pre-existing images as raw material in generating completely new creative expression by follow-on artists.
I wonder, Mr. Martinez, if your case doesn't benefit from a certain kind of hindsight. I mean, now we know who Andy Warhol was and what he was doing and what his works have been taken to mean. So it's easy to say that there's something importantly new in what he did with this image. But if you imagine Andy Warhol as a struggling young artist who we didn't know anything about, and then you look at these two images, you might be tempted to say something like, well, I don't get it. All he did was take somebody else's photograph and put some color into it. So it seems that it's harder than you say. I mean, we can't always count on the fact that Andy Warhol is Andy Warhol to know how to make this inquiry.
Yeah, I think you're right in part, Justice Kagan, but I actually think that sort of emphasizes the importance of this case. This case isn't just about Warhol. It's about the young and up-and-coming artists who want to be Warhol's successors. The artist's amicus brief, I think, says that the average, salary or earnings for a young artist is less than $50,000 a year. Think about what it would be like for that artist who wants to create new and innovative work that integrates pre-existing images. If this court were to adopt Goldsmith's rule and say that that's not going to count, it's the fact that you're doing something completely new and different in terms of meaning or message, it makes no difference, that person is going to be dissuaded. They don't want to be tied up in litigation where they're going to have to pay attorney's fees. They don't want to have their hard work then nullified and their copyrights essentially taken over by people who created the original works. So this case is very important, not just for those artists, it's also important for museums, collectors, galleries who want to display these works. I see my time's expired.
Yeah, thank you, counsel. Under your test, there are artists whose work consists of single color within a frame, right? I'm sure you recognize those.
So I've heard, Your Honor.
Yeah. Mondrian, Elbers. Let's say somebody uses a different color. The original is blue and the allegedly copyright violation work is yellow. Sort of following up on Justice Alito's point, if you've got art critics to come in and say that blue sends a particular message, yellow sends a different one, would that satisfy any claim of copyright violation?
Well, I think at the threshold you'd have a question of whether that was infringement or not. I don't think anyone can copyright a color, but just assuming it was infringement, I think you would look at...
Well, are those, maybe you don't know, but are those paintings copyrighted or?
I don't know the specific paintings, Your Honor, sorry. But
they're a frame with a color in them.
I think if it was just the color, I don't think you can copyright a color. I do think, though, let's just assume that you made other changes and there was some sort of minor change. I think you would still do the four-factor analysis. I think at factor one, you would have to look whether there's, in fact, a new meaning or message. It sounds to me like, under the hypothetical, there's no difference in meaning or message. And so I think it would be a loser under factor one.
You and I might think there's no difference, but I'm sure there's art critics who will tell you there's a great difference between blue and yellow.
And I think what a court would have to do if you're assessing whether those two works, again, assuming that there was infringement, assessing whether they had a different meaning or message, you would have to listen to those critics. And we see experts on both sides of almost every case, right? And they don't always say the things that persuade the court. And you'd have to take them seriously to the extent that you would listen to their arguments, and then you'd judge whether it was reasonably perceived, whether their view of a transformed meaning or message is reasonable, whether it could reasonably be perceived. And I think that in a lot of these cases where you're really talking about a very minor change and someone's just a knockoff artist making a bogus claim to new meaning or message, I think that juries or fact finders can exercise their common sense and say that there's no transformative meaning or message there.
Thank you. Justice Thomas?
I assume that the Orange Prince is copyrighted.
Yes, and I think that copyright's directly at issue in this case.
Let's say that I'm both a Prince fan, which I was in the 80s, and
no longer?
Well, so only on Thursday night. But let's say that I'm also a Syracuse fan, and I decide to make one of those big blow-up posters of Orange Prince and change the colors a little bit around the edges and put Go Orange underneath. Would you sue me?
For
infringement?
Would the Warhol Foundation sue you if you were to do that?
Oh, well, you're their lawyers.
I can't comment on whether we would sue you, but I think to try to get at your question, Your Honor, I think the question of whether that would be fair use, it sounds like you're, by hypothesis, asking me to consider that there's like a different meaning or message associated with the work. I don't think that's the only part of the inquiry. I think that everyone recognizes that at factor one, the ultimate goal here is to figure out whether the follow-on user is doing something sort of creative.
Oh, I'm just
that matters.
waving it, I'm waving it during the game with a big Prince face on it. Go Orange.
Yeah. I think that in circumstances like that, it's very unlikely if it was just one of you that anyone would sue you.
I'm going to market it to all my Syracuse buddies.
So I think in that case, a court would quite reasonably look at that and say that this is not the kind of productive creativity promoting use that is.
So in other words, you would sue me.
No, I would not. I think that you would probably have a very weak case against me, Your Honor.
So, but you've just changed position with Goldsmith.
No, not at all, Your Honor. I think that in this kind of circumstance, I think this is totally different because there is a transformative meaning or message, and there's an enormous amount of creativity.
Well, I had Go Orange under it. I've changed the message.
Right, but as I was saying, in addition to the difference in meaning or message, I think it's fair to consider at factor one whether the kind of transformation is the kind that the copyright laws are intended to foster, which is really encouraging follow-on artists to use creativity to kind of introduce new ideas into the public domain. I think that with all respect to your very accomplished re-rendering of Prince, I think that what Warhol did here, as even Goldsmith concedes, was very substantially creative and absolutely is consistent with the goals of copyright law.
Justice Alito?
Very often, a popular song will be originally performed by one artist, and then other artists come along and perform it in a very different way. Presumably, they think that they are conveying a different meaning or message when they alter the way it's performed. Is it possible for any of them to any of them would not be infringing the original copyright?
I think it would be very hard to imagine a circumstance in which they were not infringing ultimately under the full analysis.
Why would that be?
Well, I think it would be in part because of factor 4, because I think that you would have, it would sound like if you have Roy Orbison does a version of Pretty Woman, and then another sort of Roy Orbison style Pretty Woman emerges, I think it would directly compete with the original. So I think you'd have a very big factor 4 problem. I think under factor 3, if you're taking an enormous percentage of the work, that would weigh against you as well. I think that, would you get points on the board because of a transformative meaning or message? Maybe, but I don't think that in that kind of hypothetical that would win the day.
Justice Sotomayor?
I think my colleague, Justice Thomas, needs a lawyer. And I'm going to provide it. I see the first and fourth factors as closely related. And I think he has a better case because he's not using it at the game for commercial purposes. But even if he were, it wouldn't be related to the picture, it would be related to the team. That's no different than that case involving what mayor was it?
The Kynitz case?
Yes, exactly, in which the T-shirts took his face and put something about his statement about a party on the T-shirt, and the court said that's okay, because that was really a commentary on a social issue, and it is commercial, but in a different way. But what I don't having a problem with is, why doesn't the fourth factor just destroy your defense in this case? Meaning, you licensed directly to a magazine, which is exactly what the original creator does. And as Justice Kavanaugh said, it was licensing to the very topic that both do, which is two magazines that are talking about the life of not Warhol, but of Prince. So why isn't that direct competition?
So a couple comments on that.
And for commercial purposes.
First of all, just to reemphasize, it's not just the licensing use in this case, but just assuming we're just talking about the licensing use here. I think that Judge Kettle's analysis of factor 4 is essentially correct. And with respect to the Second Circuit, I think the Second Circuit's analysis of factor 4 was overly influenced by its impression that these were essentially, for all intents and purposes, the same work because they were both portraits of Prince. If we were going to rerun the factor 4 analysis, and if you wanted to look at it, I would just suggest you look at the briefing in the lower courts because we obviously didn't do it here. I think the key things that I would suggest that would deserve attention would be who's the audience for Warhol licensing versus Goldsmith's licensing. I think there's substantial record evidence showing that the audience is different in terms of the people who would do the licensing, where Goldsmith's works were predominantly being targeted more to photorealistic, sort of like a Newsweek, or in most cases like rock and roll magazines and other kinds of publications. I think you'd look at the price to see whether there were market substitutes. There you'd see that Warhol's works, even at the licensing as opposed to the purchase of the original works, were selling for a lot more. I think you would look at the aesthetics. The aesthetics are quite different. And I also think you would look at the transformed meaning or message. All those things, I think we would win for the reasons that the district court said. If you disagreed with us on that, I think maybe you would say this is a fact issue that's got to go to a jury, but it certainly wouldn't be summary judgment as to factor 4 for Goldsmith.
Justice Kagan? Justice Gorsuch?
In 1984, did Vanity Fair need to pay Goldsmith?
No, Your Honor. I don't think they needed to pay. But I think what this court recognized in Campbell is that if people offer to pay or do pay, that doesn't make a difference. I mean, I think in the Two Live Crew example, they in fact did try to get a license, even though, as the court recognized, it wasn't required.
And then in your point about up-and-coming artists, obviously that can be played both ways. And some of the amicus briefs, and I just want you to comment on this, one of the amicus briefs says your position poses an existential threat to photographers. So I just want you to comment on that.
We absolutely strongly disagree with that.
And why, though?
Because we think that the kind of transformation that's important here is something that really it creates a new original work in a fundamental way, not just because the work's in a different form or because it has different colors, because it has a different meaning or message. And I don't think in circumstances, especially if we are right on factor 4, that there's either zero or not much impingement on her market, we don't think that actually destroys anyone's livelihood. Rather, we think that promotes creativity and artists of all kinds.
Thank you.
Justice Barrett?
Mr. Martinez, I think one of the problems that you have, as evidenced by a lot of the questions that you've been getting, is with the derivative works protection, which in 106(2) actually talks about transforming any other form in which a work may be recast, transformed, or adapted. And it seems to me like your test, this meaning or message test, risks stretching the concept of transformation so broadly that it kind of eviscerates factor 1 and puts all of the emphasis on factor 4. I mean, when you've been asked about book to movie and songs, you keep flipping to factor 4. So if a work is derivative, like Lord of the Rings, book to movie, is your answer just like, well, sure, that's a new meaning or message, it's transformative, so all that matters is 4?
I don't think that Lord of the Rings has a fundamentally different meaning or message, but I would have to probably have to learn more and read the books and see the movies to give you a definitive judgment on that. And I recognize reasonable people could probably disagree on that. I think that with respect to the derivative work issue, I think textually it's very important that in Section 106, when it's talking about in Section 101, when it's defining derivative works, and later in the copyright statutes when it's giving protection to derivative works, it says it's subject to Section 107. And so just textually, we know that the fact that you're a derivative work doesn't mean fair use is out the window. So is there a tension between those two in some cases? I think probably there is some tension. And I think that what it means is that you need to do a very careful analysis of new meaning or message. And it's really going to be only in the cases that there really fundamentally is a new meaning or message that are going to be able to sort of satisfy that first factor. With respect to the balance between factor 1 and factor 4, I think factor 4 plays a role when it comes to some of the very challenging hypotheticals that were put forward by Goldsmith and the government and by the court. I don't think it's really that big a deal in this case, though, because this case really involves a very fundamental transformation in meaning or message, and we think very little impingement on the market under factor 4.
Thank you.
Justice Jackson?
Yes, so I've been trying to figure out when you continually say transformational meaning and message, and you're focusing on meaning and message, it feels like it's doing a lot of work with respect to your factor 1 analysis. And I think that it might be because you're conflating meaning or message with purpose. What I've heard you say a couple times is that the purpose of Warhol in this situation was to essentially convey a different meaning or message. That, the original was conveying Prince in a vulnerable light, and so the purpose was to convey him in a more iconic way. But the statute, and I think this is something that Justice Sotomayor has sort of focused on, and to some extent Justice Thomas with his hypothetical, the statute seems to be looking at purpose in a different way. That it's saying The purpose is, are you using it for a commercial nature? Is it going in a magazine or is it going to a school? When you look at the actual text of the fair use factors, it's purpose and character of the use, including whether such use is of a commercial nature or for nonprofit educational purposes. So I think you're actually treating purpose differently than in the statute. So can you?
Sure. So I think we're definitely not conflating meaning or message with purpose. I think what we're saying is similar to, it's not quite conflating, but we think they're related. We think that one way to get to a different purpose is if you have a different meaning or message. Let me just give you an example. Say that you had a portrait of Abraham Lincoln, and Abraham Lincoln was depicted in a heroic way. And then you had another portrait that depicted him in a very negative way. I think that the purpose of both of those works would be fundamentally different.
Absolutely and not what the statute says about purpose. You just made my point exactly.
No, you're
that it's not, there may be a different meaning or message, but if both of those depictions are going in a magazine for a commercial nature, the purpose, the reason why you've used it is the same.
Well, let's just look at the moment of creation. At the moment of creation, they have different purposes, I think. One is to show Lincoln as a good guy, one is to show him as a bad guy.
So what is the work of including whether such use is of a commercial nature or for nonprofit educational purposes? I thought that was Congress telling us what kind of purpose it cared about.
Right, I think that's, Congress is saying that, it says including, so it doesn't say that's the only factor, number one. And number two, as this court held in Campbell, the commercial use is not like the main event, and certainly not the only dispositive event. And that was actually the exact issue in Campbell.
No, but it's a type of purpose. Why are you doing this? You're saying, why am I doing this? Because I want to depict Abraham Lincoln in a heroic way. When Congress is saying, why are you doing this? Because I want to put this, are you doing this because you want to sell it commercially? Or are you doing?
But Your Honor, I think if that were the way to the only level of generality to look at it, I'm not denying, by the way, that I think you could look at purpose in that way, and that would also be a legitimate way of looking at it, of considering it. What I'm saying is that you can't exclude meaning or message, and I think the best case to show that is Campbell, because Campbell, again, you have two works of popular music that at your level of generality have the exact same purpose. We're entertaining people on the radio. I listened to them on Spotify yesterday. They have the same purpose. What's different between them is the difference in meaning or message.
Why isn't that character? Why isn't the difference that you're pointing to character, and that's something you factor in? I'm not excluding it. I'm just saying it's not purpose.
We think it's both purpose and character. We think it's purpose because the meaning or message that someone is communicating is tied up with their purpose. If I give a speech that says, vote for Biden, or vote for Obama, or vote for Mitt Romney, I'm giving a speech, but the purpose in giving the speech is to convince people of my meaning and message.
All right, one final question. If you, let's say you win on this point of the Second Circuit made a mistake with respect to the way in which they treated meaning and message, and the court vacates, would you want us to go on and deal with the other factors?
I don't think the other factors are briefed up in this court. And so I think, there's some questions that have been raised about the other factors. I think it's reasonable to think that there might be some factual issues there that should go back, probably maybe even back to the district court. It could even require a trial. We won a summary judgment on that, but if you thought differently or had concerns about Judge Kettle's treatment of the other factors, I think that would be the appropriate disposition. Thank you, Your Honor.
Thank you, counsel.
Thank you.
Ms. Blatt.
Thank you, Mr. Chief Justice, and may it please the court. Fair use is an affirmative defense. It involves a multi-factor balancing test, and factor one focuses on purpose. What is the reason or justification to take another's copyrighted work? The reason can't be to avoid paying the customary price or the drudgery of coming up with something fresh. The copier has to explain why it needed and not just wanted to use someone else's expression. Here, petitioner has never given any reason for copying Ms. Goldsmith's picture to commercially license Warhol's orange prints in 2016. Indeed, Warhol got the picture only in 1984 because Ms. Goldsmith was paid and credited. Petitioner responds, Warhol is a creative genius who imbued other people's art with his own distinctive style. But Spielberg did the same for films and Jimi Hendrix for music. Those giants still needed licenses. Even Warhol followed the rules. When he did not take a picture himself, he paid the photographer. His foundation just failed to do so here. Petitioner argues adding new meaning is a good enough reason to copy for free. But that test would decimate the art of photography by destroying the incentive to create the art in the first place. And it's obvious why the multi-billion-dollar industries of movies, music, and publishing are horrified. Petitioner's colloquial definition of the word transformative is too easy to manipulate. The Act also gives creators and not copiers the right to make derivative works that transform the original into new ones with new meaning. If petitioner's test prevails, copyrights will be at the mercy of copycats. Anyone could turn Darth Vader into a hero or spin off All in the Family into the Jeffersons without paying the creators a dime. I welcome your questions.
Ms. Blatt, you, in your brief and even in your opening statement, you focus on purpose in 107. You did not mention character in your opening statement, and you don't give it a primary role in your briefs. What role does it play in your analysis?
Character, I mean, I think we agree with their definition. The character of the use of the copying is one of commercial licensing. And the purpose, I mean, it's just, I think that they are very similar here. The purpose and character of commercial licensing, the purpose and character of a parody, I guess, is very similar. So I'm not sure that they ever play, and haven't seen them play a distinct role in any of the case law or in the common law for that matter.
How can you inquire into purpose and character without thinking about meaning or message? You know, what the first factor is really asking you to do is to say, what is this use doing? And how can you answer that question without thinking about the use's meaning, its message?
We absolutely think meaning and message is relevant as it relates to purpose.
So that is different from what the Second Circuit said, because I thought the Second Circuit took it out of the analysis entirely, said it was irrelevant to the question.
No, and I think that's very unfair to 3 members of Article 3 who 3 times said meaning and message is relevant. Yes. Well, I find it insulting to the Second Circuit panel when they said, do not assume the role of art critic and buy this notion of, well, Prince is shy here and he's iconic there. But of course meaning and message is relevant as to purpose. I mean, I can just keep reading you quotes, but you know how to read a decision as best as I do. But on the very same page they're yakking about, it says it has to be reasonably perceived as having a distinctive artistic purpose, one that conveys a new meaning. It's just saying what you can't have, and what we're all unified on, the government, us, and all of our amici, is you cannot have a bare purpose to add new meaning to someone else's art for profit. And if that's all he has nothing else. He has no justification for this other than, I wanted to take someone else's art and put my own distinctive style on. And one expert thought that Prince looked happy or dead or, I don't know, larger than life. And one thought the artist here thought Prince looked real. And so that is all the Second Circuit had, was they had a district court opinion that went completely, this is a Warhol, and oh my God, it's a Warhol, so it's transformative by definition. And the Second Circuit said, no, we're not going to do that here. You're going to have to give me something more than this is a Warhol with a distinctive style.
And where do you get the idea that you have to need the original work?
So where we get the need is from the 5 times in Campbell that the court said it, but it's...
So Campbell doesn't say that. Campbell says, well, if you need the original work, that's the paradigmatic case. But it doesn't say that if you don't need the original work, it can't be transformative. So,
yeah, let me just state our test. When the defendant has an asserted purpose for copying someone else's work, you ask, was the copying of the original needed to best achieve the copier's purpose? Now, in Campbell, it is very significant that they are misciting and quoting Campbell. The court did not hold it could be reasonably perceived as having a new meaning. The court actually held it could be reasonably perceived as criticizing or commenting on the original. And without that necessary element, and the court 5 times said it was critical, it was the heart, and without the need to mimic, you have no claim to the victim's imagination. And why we know that new meaning could not have been the test?
But Campbell starts with a statement of things being new and different and encouraging creativity to give new and different things the kind of fair use pass. And then Google follows up on that. And it doesn't talk about in your language at all. and it uses Warhol as an example of how somebody can take an original work and make it be something entirely different, and that's exactly what the fair use doctrine wants to protect. So, I take it that Campbell has some language that cuts your way in the sense of saying, well, if you are commenting on the original, that's real fair use protection. We almost don't need to go any further. But if you're not commenting on the original, there's still the possibility under Campbell, and then certainly under Google, that yes, this is fair use because it's the kind of thing we think of as truly transformative.
So I would say you should look at a holding over a dicta that uses a non-statutory word transformative when the actual word transformation is in the statute. The dicta that they're relying on is saying, we think, that when you have a parodic purpose and in the process of shedding light, just quoting your word, shedding light on the original, you benefit society and create new meaning. But why and why all that matters in this case is they had an affirmative defense and they just didn't give you a good reason for copying. And why that Campbell just completely rules that out is what mattered in Campbell was exclusively the parodic purpose. If new meaning and message were relevant, the court would have been spending the whole time talking about the pretty woman you wanted to meet on the street versus all those not so pretty women you didn't want to meet on the street that were hairy, bald, and two-timing Mr. Mix, and one was pregnant and wasn't sure whose friend it was. No one was talking about the women's personalities in Campbell. It was just what you're trying to criticize. No one was talking about the personalities of George Washington in Folsom versus Marsh. It was just, is this a biography about Washington? And no, that's the same
Ms.
purpose.
Blatt, you said that the only thing that's different was the distinctive style of Warhol. I think your friend's point is broader than that. It's not just that Warhol has a different style. It's that unlike Goldsmith's photograph, Warhol sends a message about the depersonalization of modern culture and celebrity status, the iconic, and he goes through the different features to support that. So it's just a different style. It's a different purpose. One is the commentary on modern society. The other is to show what Prince looks like.
Yes, I think that, right. And when I say distinctive style, his distinctive style by definition is commenting on celebrity and dehumanizing him. And we're saying that level of what is the personality, what do we perceive in Prince's face, or what we think about when we think about what the author intended, would just drive a giant hole through a derivative work, which by definition is a work that adds new meaning to the original. And any time, I know he wanted to stick to book versus movies, but any spin-off, any adaptation it just starts with a new meaning. Take All in the Family. Norman Lear would be turning over in his grave right now. He had more spin-offs than any show in American history. The Jeffersons was about a prospering African-American family who lived on the East Side. All in the Family was about a white bigoted living in Queens who couldn't keep up with society. And
but they both were television shows, right? And they were portraying a particular socioeconomic whatever element. This is a whole different thing. The one is a picture. You want it there to show what Prince looks like. So it's a photograph, I'm sure composed in a particular way and all that. The other, you're not looking at it. The message you have, if you put them side by side, the message is not the same. The one is Prince's hair is like this, his expression is like that. The other one's entirely different. That's why they put the black around one eye. That's why it's just the disembodied face, all of that. And you don't say, oh, here are two pictures of Prince. You say, that's a picture of Prince, and this is a work of art sending a message about modern society.
And that just would turn Folsom versus Marsh on its head, which was they had a completely imaginized autobiography of George Washington, the first president, and all that mattered to Justice Story was that both works were depicting the life of George Washington. Your test lies madness in the way of almost every photograph to a silkscreen or a lithograph or any editing. I guarantee the airbrush pictures of me look better than the real pictures of me, and they have a very different meaning and message to me.
Well, I think that's not right. I mean, I think you would look at both of them, and one would say, those are pictures of the same woman. This one may look a little better than that one, but it's the same woman, it's for the same purpose, it's to show what she looks like. But if you had a picture, a photograph of you, and then a Warhol, it's just not the same thing. You look at the Warhol thing and you say, oh, that's you know, that's
The problem,
counsel. The
the
other
problem
one-
with this line of theory is you're just putting photography in its own category and saying photography can just be ripped to shreds because you can always edit a picture and make these arguments, black and white versus color, et cetera. But once you move to any other type of medium, books, movies, and songs, these giants, there are giants in all these creative fields who, by the virtue of the fact that they took someone else's work and transformed it into shows that are way more valuable. If I could just talk about Factor 4, because his answer was just astonishing, that the first half of his argument was solve everything under Factor 4. The last half of his argument is, we win in this case under Factor 4 because of a trial in a different market. And imagine my Jefferson's hypothetical. Everything he said about Warhol versus a Goldsmith is the same article you could have said about the audiences that want to watch, or Mork and Mindy versus Happy Days. That is one character from Happy Days involving some Martian who came in, and Robin Williams was so funny that a whole new show was created called Mork and Mindy. They had nothing to do with one another, different audiences, and under his view, just everything he said about Factor 4, you'd have a trial in every single case, and he just basically forces all authors to go into Factor 4 with one hand tied behind their back, where there's already a finding that this is a transformative work. Ms. Goldsmith lost under summary judgment under Factor 4 because the district court said, hey, you have a transformative Warhol, and it is inconceivable that somebody would want a shy-looking Prince over the same market that wants a happy, iconic Prince.
Ms. Blatt.
Ms. Blatt, what do you think the Second Circuit meant when it yacked about art critics, about judges not being art critics? Was the point that a judge is supposed to determine whether a person who knows nothing about either of the works of art is supposed to determine whether they seem different? You can't have testimony, evidence about the meaning of those things?
So the district court, the Second Circuit had left open a very large amounts of type of fair use that I think, transformative purpose that we would not think is correct, where I think in their view, you can look at it objectively. What the the Second Circuit was saying about don't assume the role of art critic was the notion that you would have such a level of specificity as to the vibe that the character being depicted was giving off, just like the notion of we could talk about all kinds of movies and adaptations. Was the character in Jaws, the book, different than the way the sheriff was depicted in the movie? And we could give The Shining is the best example. We know Stephen King had a very specific view of who Jack was. It was basically him, and it was a tragedy. And we know what Stanley Kubrick did to it. He said, "I don't like your Jack. I'm going to do my Jack, who's a horror film."
Suppose that the Mona Lisa was copyrighted and somebody, really skillful copyist, made almost an exact copy. Most people could never detect the difference, except the copyist changed the color of her dress. If you showed those two to most people today, they would say, well, all right, brown dress, blue dress, red dress doesn't make any difference, right? That's not really important. But if you called somebody who knows something about Renaissance art, the person would say, that makes a big difference. If that's a blue dress, that's sending a message. If it's a red dress, that's sending a different message.
So where I think all this goes wrong is you're just focusing on meaning and message independent of the underlying use. In this case, the statute just by its terms is talking about use. And in the case of the Condé Nast, the use is to portray Prince. If you reprint our pictures, whether it's Miss Goldsmith's or Andy Warhol's, you're commenting on the pictures. I don't think you're saying anything about Prince. Your use of those pictures is to describe and discuss the case. Same way with the briefs and news articles. These are news reporting or any kind of commentary about the pictures. And in your Mona Lisa example, fair use never, nobody sues an artist or sued Two Live Crew when they were in the recording studio. You have to look at the actual use. And in Campbell, the court said, in a parody, fine, we'll spot you that, but we'll send it back for a trial under Factor 4. But if you're going to start using it for advertising, that doesn't count as an appropriate use under Factor 1. The same thing was true in Sony. It wasn't the recording that the court was focused on, it was the time shifting. When you watch it at home, not for money, not for profit, that's the only way you're going to be able to see the show that the networks were offering.
So Ms. Blatt, what about the use in the museum like a Warhol hanging in the museum versus the use in Condé Nast and Vanity Fair? Is there any difference?
Absolutely, and for a variety of reasons. The first is factor 4, and we have the largest museum in the world sitting next to me on my right, who's on my right and not on my left. Factor 4 is just different. Goldsmith doesn't compete in that market. On Warhol, if I can just take you away from Prince, and also now that this Prince series is famous, I don't see how any museum can't display these. But the Prince series is very complicated because of the license. But if their poster child for museums is Andy Warhol, let them tell you what Andy Warhols they're worried about. He took all the pictures of the famous ones, or he got a license. Marilyn, who's I think worth a lot of money now, that picture's in the public domain. That guy didn't renew the copyright, Gene Corman, before he died and the copyright law was passed. So I don't know what they're worried about. If you look at the pictures in the museum brief, it's a bunch of naked women. And no one is trying to say that naked women are going to be taken down from museums. There was nothing that, the pop art they were...
Maybe there's a different point about museums, and the point is, why do museums show Andy Warhol? They show Andy Warhol because he was a transformative artist, because he took a bunch of photographs and he made them mean something completely different. And people look at Elvis, and people look at Marilyn Monroe or Elizabeth Taylor and Prince, and they say, this has an entirely different message from the thing that started it all off. And that's why he's hanging up on those museums, and that's why whatever the Section 4, the Factor 4 inquiry might be, that's why it's hard to look at it and not say under Factor 1, that's transformation.
Well, in our view, I think the government might have a different view under museums, but everyone agrees that in museums, there's going to be fair use. And there's also particular provisions, mainly 109, that both our brief and the government's brief talk about, that separates for display for museum purposes. But under where I think I disagree with you is just that the display in a museum of Prince is still copying and still using Miss Goldsmith in a way that doesn't justify the copying of Miss Goldsmith. Now, she doesn't have market harm, it's still fair use, she can't sue. All remedies as to museums and to possession and sale were waived here in the complaint. He read the complaint accurately, but it was all expressly disclaimed. And so all we have here is the commercial licensing. But you also have a disclaimer both in the Second Circuit and the Supreme Court that Warhol doesn't have a claim, that Ms. Goldsmith doesn't have a claim for museums.
Excuse me, do you have a claim for the original Prince series? The original painting?
So the possession and physical, it turns on the license. Because remember, Warhol, these were produced under a license, and so it's unclear whether all 16 were made pursuant to that license or made as drafts. And if Warhol wants to, and the Warhol Foundation doesn't even own any of these, so the possession and sale wouldn't be with respect to them. But assuming that they were all lawfully created, they can be. Then this turns under 109. Which says you can sell the possession. What's not protected is just the commercial licensing.
Judge Jacobs below said he didn't think that the Second Circuit's decision or injunctive relief encumbered the original Prince series, I'm quoting him, I think, or anything that was hanging in museums and things. Do you read, what's at issue here? What use is at issue? Is it the 2000?
Only the commercial licensing, and I think 46A.
What commercial licensing?
Of Orange Prince in 2016, plus is a request for injunctive relief for other similar commercial editorial licensing, so for magazine usages.
Can we go back to you?
Thank you. Oh. Thank you, counsel. Justice Thomas? Justice Alito? Ms. Kagan? Justice Jackson.
Yes, thank you. Can we go back to the necessary condition? Because I'm still not quite understanding it. First, I thought there was something in the legislative history that I may have read about Congress considering a necessary condition and taking it out. Does that sound familiar to you?
No.
No. Okay. Maybe I made that up.
That doesn't mean it's not there. The legislative history, though, is very helpful because it's got, and I highly recommend the Manel, Balganesh, Jane Ginsburg brief because it gives you all of the complete history and background, and they would read it a little beyond relation back where it's necessary to copy, but it basically is limited to these very core uses.
But what about commentary? That's what I'm worried about, right? That parody, I understand you would say it's necessary, and so that would fall into your fair use test. But something like the Campbell's soup can, where we've already established perhaps he could have used some other item to make the same kind of comment, would that not be necessary?
No, I think that Campbell soup fits in two places, and Justice Kennedy's concurrence in Campbell is really good on this point. What Justice Kennedy is saying is that the writer can always pick his target. You can always pick what book review you want to critique or what song you want to parody. So it's never, you have to say, well, you didn't necessarily have to pick on my song. So Warhol was entitled to comment on Campbell soup as a form of talking about consumerism and make whatever broader point he wanted to make about society. But the Campbell soup label, and not only is it a completely different purpose because one's an advertising logo that goes on a supermarket shelf to a work of art, but, and I think the government's brief says this, he can't have used a generic soup can. He had to use the Campbell soup logo. The same as if he had picked Cheerios. It would have been really weird to do, I guess back then they didn't have the giant Cheerios, but you got to use Cheerios to make your point about consumerism and brand loyalty.
Necessary.
Absolutely necessary.
Some branded
and
product.
what the government would say, and obviously the government can speak for herself, but they would say at least useful, and we're okay with that. We're actually okay with anything other than the new meaning or message test.
But the Second Circuit looked at this a certain way. And are you saying they did it wrong?
No, they did it absolutely correct because they were just rejecting the district court and saying, we're leaving open everything, but something that says Prince looked iconic versus Prince looked shy based on these interpretations of what one might reasonably think of Prince's, I don't know, mood or something, or personality. But I read the Second Circuit is way broad, saying you don't have to comment. I mean, I think they leave open all kinds of stuff like collages. Like if you took a picture of Prince and made him into like Goldsmith's Prince and made him into a big butterfly, I think they would say that's completely fair use. So I think for your purposes, and which is what's driving all the, the amici being kind of very upset here, is just to reject a new meaning or message test where it's just a bare, unadorned new meaning or message test. It's not tied to any purpose other than I wanted to make some money off some art and I had some really cool idea here.
Thank you.
Thank you, counsel. Ms. Dubin?
Mr. Chief Justice, and may it please the court. Two questions drive factor one. Does the use serve a distinct purpose or instead supersede the original? And what is the justification for copying? Both point against fair use here. The Foundation has never tried to show that copying the Goldsmith photograph's creative elements was essential to accomplish a distinct purpose. And the Foundation commercially licensed Warhol's prints to serve the same purpose as the original, depicting Prince in an article about Prince. Using another artist's work as a starting point to turn around and compete directly with the original has never been considered fair. The Foundation suggests otherwise only by urging you to look primarily to what the silk screens mean rather than why the copying was justified. The court should reject that test. It misreads Campbell, it requires courts to inquire into the meaning of art, and it would destabilize long-standing industry licensing practices that promote the creation of original works. Sequels, spin-offs, adaptations all become fair game if conveying a different meaning confers license to copy. I welcome the court's questions.
Counsel, in what way is the government's position different from that of respondents?
We agree with respondent that the most straightforward way to establish fair use under the first factor is if your use is commenting on the original, criticizing it, or otherwise shedding light on the original. But fair use is an affirmative defense, and we would leave open to defendants in various cases to establish that their copying was justified for other reasons. The problem with petitioner's approach here is that they haven't tried to establish that the copying was justified, just that the meaning of the works was different, and the court has never recognized that to be a sufficient justification under the first factor.
Well, you agree, don't you, that the Warhol work is not a commentary on the Goldsmith photograph, right?
We would agree, and they have never argued that.
And Goldsmith had a very different purpose than Warhol. She was photographing Prince. This is what he looks like. Now, a lot goes into that composition. But it's not that Warhol's work was just a different composition, was it?
We think that the relevant question is what is the use at issue here? And the use at issue here is to depict Prince in an article about Prince, which is very similar to the purpose at issue when Goldsmith.
But if you really wanted to know what Prince looks like, you wouldn't get that from Warhol's depiction. He doesn't have one eye that's, blacker than the other. His head doesn't float in the air as it does in Warhol's, but not in Goldsmith's. And that's because, I think your friend on the other side would say, it's because the purpose of that picture is not to show you what Prince looks like. It's supposed to show you a particular perspective on the pop era and celebrity status. No?
Those changes that Your Honor is discussing are the same sorts of changes that really accompany the adaptation or transformation of any derivative work. You could imagine all of those comments being made about a book being transformed into a movie. Those are comments about a change in style, a change in aesthetic appearance, and things of those nature. That has never been thought sufficient under the first factor to be a different purpose.
What about character? Is that sufficient for character? You talk about them together, and so is character doing different work at all in this analysis?
The court has long considered them together as a unit and done an inquiry into purpose and character together. We think that if you were inclined to do so, you could look at character as focusing more on the commercial nature of the works of the use at issue, and the purpose as looking to, what was the justification for copying. But either way, you would come to the same analysis here, which is that this is a highly commercial use that usurps the market for the original, and that the justification for copying isn't present.
But the meaning of message, you say, is not indicative of character.
That's not our position. The position is that meaning or message can be relevant insofar as it assists the court in determining what is the purpose and character. And I think that's exactly what the court looked at in Campbell. In Campbell, the court looked at the meaning or message of the Two Live Crew song to determine if it was in fact a parody and therefore had the purpose and character that we're looking for under Factor 1.
The purpose of all copyright law is to foster creativity. So why shouldn't we ask at Factor 1, not in a determinative way, there's Factors 2, 3, and 4, but in Factor 1, well, is this really creative? Is this thing we have here something new and entirely different? It seems to fit right into why we're having this inquiry in the first place.
The purposes of copyright law are to serve as the engine of free expression, but the balance that Congress struck in achieving that is to say we do that best by protecting the rights of original creators and protecting the incentive to create with a safety valve.
Except when we don't. I mean, we protect original creators, except when we don't, and the purpose of the entire thing is to foster creativity. So why shouldn't we ask whether at the follow-on level there really is creativity here? And then we can ask a whole bunch of other questions about markets and so forth. But to take that out of the analysis, to say it doesn't matter that the follow-on work is adding something of real significance to artistic expression, why would we do that?
I think the most significant difficulty with petitioner's approach is we're not trying to take it out of the occasion. It's not about putting points on the board. It's whether it goes to the purpose and character of the use. And I think maybe this helps with what Your Honor is driving at. In the statute, there is a specific right given to the copyright holder to derivative works, to prepare derivative works. And that provision looks to whether a secondary work transforms. That's the language of the statute, the original. So Congress thought about this question and gave that right to the original copyright holder. Someone who wants to make a creative, very, very creative work can go and license that work to use it, or they can justify why they needed to take this work or why it was essential or highly useful to take this work in order to create the work. But what's going on here is you have someone who's just saying, my second work was very creative. My second work was transformative in the colloquial sense, and that doesn't fit within the definition of derivative works versus the safety valve for fair use.
Can I just paraphrase what I thought I heard you say, because I'm not an expert in this area. So the whole of copyright law itself in this area is to give the person who has the copyright the right to make other uses of the thing. It's sort of like a property interest in, I, because I hold the copyright, get to make other uses. When someone else makes another use of your thing, you then can question. You then say, why are you using my thing to do your work? And I think your argument is if that person says, I'm using your work because I have a better idea, or because I want to add a little thing to it, or because that's not going to be good enough. They have to say, I'm using your work for some other purpose that's outside of or in addition to, I want to add a new meaning. Am I at a very high level of generality? Did I sort of get what your point is?
I think you got it exactly right, Justice Jackson. That is our point. The point is that you have to justify the copying, not just explain why your work is a creative addition to the world of creative additions. And I think that's important because of the derivative work right that I was discussing, and it's important because of sort of how the licensing regimes work across industries, where there are many, many very, very creative people who are producing derivative works, whether it's the one that Respondents' Counsel already addressed, but it's Spielberg, it's Scorsese, it is so many people who do tremendous creative additions to the work that they're using, but because they don't have the sort of justification for copying, they need to get a license.
How do we fit your answer to the following scenarios, okay? Do you acknowledge that a commercial licensing would be fair, such as an authorized reproduction of Orange Prince in an art magazine or in a book about Warhol?
We would analyze that by running through the 4 fair use factors, and I think in that
How would you deal with the first one? Because it is a commercial use. It's use of a painting that you say is a derivative work. So how do we explain that?
Right, I think factor 1 and factor 4 might play out differently than here. Factor 1, you might say the purpose is to say something about Warhol, to teach about Warhol, and under factor 4, you might say that it's very unlikely that that would harm the market for the Goldsmith photograph, because her photograph could not be used for that sort of occasion.
So how about the commercial license for Orange Prince, like happened here? Why do you say it doesn't fit for a magazine about Prince's life?
Because the purpose of the Goldsmith photograph is to depict Prince. And while there might be differences in how she did it and how Warhol did it, they were both being used in this, when you compare the two, the work and the use, they're both being used for the purpose of depicting Prince.
So let's go back to Vanity Fair, which was, it was paid for, but assume it wasn't, okay? But Vanity Fair was an article about Prince, but its focus was on his superstar status, his consumer sort of life. It seems as if those purposes coexisted, not coexisted, but were joined at the hip with using a Warhol, because Warhol was known for making commentary on the very same issues. So why would they have needed a license back then?
I think the key to thinking about this case is, what is the justification for borrowing? Why did you need to take the creative elements of the Goldsmith photograph? So to produce the Warhol version of Prince, Warhol could have taken a photograph of Prince himself. He could have used other photographs. He didn't need to reproduce the creative elements of the Goldsmith photograph to have that effect.
Well, what if Andy Warhol, what if Prince would not have sat for a photo by somebody sent by Andy Warhol, and Andy Warhol wanted to comment on Prince, and what he needed was a full-face portrait looking straight ahead. And I don't know how many of those were available, but he had to take one of those, so he chose this one. Wouldn't it be highly necessary for him to take one of those photos to do what he wanted to do?
You might have a different argument in a case where, you know, someone has passed away and there's only one version of the photograph that you could possibly use. That might be a different case, and you might be able to establish a justification for borrowing. And like I said, we don't want to foreclose additional justifications working. But this is a very different case. What happened here is that Vanity Fair, because they had a license, picked this photograph and gave it to Andy Warhol so that he could produce an image of it. And that's the opposite of having a justification for borrowing. I wanted to start here because it was a very good photograph of Prince, and that enables Andy Warhol's duplicative methods, because it works to reproduce that as a photographic negative.
Is that dependent on the fact that he could have picked another photo? Do we know that there were other photos that met the criteria that I mentioned?
There were other full-face photographs of Prince. I think they're in petitioner's brief. And I also think very much in Andy Warhol's life after the 1960s, when he was sued for copyright infringement, he often took photos of the people he was going to paint. And so that, you know, is Dolly Parton, Jane Fonda, and many other celebrities.
So I have a question about the derivatives. When I asked your friend on the other side about derivative use and the tension between the transformation point here, and you also pointed to the language that I asked Mr. Martinez about the transformative in the derivative use provision, he responded to me, well, sure, but that's also subject to the fair use statute, so they have to be read in tandem. What's your response to his point?
We think they have to be read in tandem, although the word transform is in the provision for derivative works, and it is not in the fair use factors. It was, I think, a shorthand for the purpose and character inquiry drawn from Judge LaValle's articles, which all look to transformative purpose, not transformative content, which is, I take it, how they are framing the case. I do think that if you are sort of thinking about how to balance those rights and carve out space, you would never want a reading of the fair use safety valve that totally eviscerates the derivative work rights. And that's what we're particularly concerned about with petitioner's test here, because so many derivative works can be described as conveying new meanings or messages.
You said in your opening that the position of petitioner would destabilize longstanding industry practices. So can you flesh that out, why you think that?
Yes, and that follows up right up from what I was just saying to Justice Barrett, which is across industries, there's one of the greatest incentives given to original artists to create, particularly in spaces where their original work maybe doesn't have the same commercial viability as derivatives. The incentive is the licensing of derivatives. So whether that's photographers, books who are hoping that a movie takes their book, things of that nature. All of those, I think, would be subject to a different meaning or message analysis like petitioner proposes here. And so it's whether, I think Justice Kagan said earlier, the plot is changed, the storyline is altered, new characters are added. Those seem to me it's very hard to distinguish those from what's going on here, which is suggesting that a change in a particular face from vulnerable to iconic is enough to justify fair use under the first factor. And petitioner has said today that it's really more about putting points on the board, but the way that I had understood their test is that they said that that sort of meaning or message renders fair use presumptive, and that's in their brief at 40, and I think that's the particular danger of an approach like that, is how much meaning or message could tilt the test and how frequent you'd be able to find a new meaning or message, and how hard it would be to disprove.
So if we agree with you that the first, about the mistakes, or affirm on the grounds of the first factor, why wouldn't we just vacate and send it back and let the Second Circuit go ahead and do all the other aspects of the analysis? You ask us to affirm, and I'm just wondering, since it wasn't briefed 2, 3, 4, why wouldn't we send it back?
If you agree with us?
Yes. Are you asking to affirm?
Yeah.
Yes. And my question is, why are you asking to affirm the entirety of the Second Circuit's analysis in this case, as opposed to sending it back and let the rest operate? Is that not what's happening here?
The Second Circuit ruled on the second, third, and fourth factors, and we did so correctly. So there's no reason But
that part is not briefed. I mean, we haven't gone through the second. Is the second, third, and fourth factors briefed before us now?
Petitioner only sought certiorari on the first factor, so I think if you were going to reverse or vacate, you would do so on the first factor, but I think it is well within the court's purview to affirm based on agreeing with one of either how we have approached fair use under the first factor, or with agreeing with the Second Circuit and then affirming on the rest of the Second Circuit.
But would we go through the rest of the analysis? We wouldn't talk about it, we would just affirm and move on.
I think that would be what you would do if you were limiting yourself to the way that petitioner has framed this case. If there were things at the point the court wanted to clarify to help the lower courts in this difficult area on a case-by-case basis, in the second through fourth factors, the court could certainly do that.
Can I ask the question slightly differently? Which is, let's assume we adapt petitioner's first argument, or the argument first raised here, because he seemed to be saying in his briefs that meaning trumps everything else. But here he says it's only one variable. Let's assume that we were to find that the Second Circuit should have given more weight to meaning, and so that the first factor is at either an equipoise or slightly favors him, or whatever, or favors him a lot. Why would we affirm and not vacate and remand?
So we think that the Second Circuit did consider meaning or message. We agree with respondent. They do mention that they considered meaning or message several times in their analysis. But if the court found that they didn't weigh it heavily enough, or you agree with the position being put forth by petitioner today, then I think the right answer would be to vacate and have the court run the analysis with that change on factor one.
Thank you, counsel. Justice Thomas, further? Justice Alito? Justice Sotomayor, anything further? Mrs. Kagan? Justice Gorsuch?
I'm a little uncertain about the government's position on what it means in factor one. The purpose of the use could mean, as we've discussed, they're both being used for identifying an individual in a magazine. Okay. Or it could mean the purpose of the use could have something to do with the artistic message being conveyed. I've heard bits of both flavors from both sides in this case. And certainly the Second Circuit thought that the latter idea, that there's some artistic message that's relevant at step one, is part of the analysis. And what is the government's position? I could see possibly saying, oh no, it's only that it's being used for commercial purposes in a magazine. It's the same use of the image, and that any differences between the images is something that we take account of maybe in factor three, which has to do with the amount and substantiality of the portion used. Can you help clarify that for me?
Yes, we think it's principally the purpose and character of the use. It's a broad inquiry, and we're not trying to carve out certain justifications from not being made. But what you are looking at is whether you have a purpose along the lines that is distinct, right? It's distinct from the original purpose, and that the use at issue, it was essential for you to copy from the underlying work to accomplish that purpose. And I think that the court, what the court...
I'm going to stop you. Yeah. I'm sorry, but that isn't helpful for me.
Okay.
Okay? And maybe I'm being too dramatic in the difference between the two, but I do see the way to read number one, the first factor, in two very different ways. The purpose of the use could be the purpose of this particular use in a commercial setting, right? I mean, because it does go on and talk about commercial versus non-commercial. And here we would say they're both being used in magazine covers to identify an individual. Okay, done. Or one could say, but Andy Warhol had all sorts of different subjective meanings, and a reasonable viewer could take away different meanings from them. Is that second thing relevant at all at the first step in the government's view? And I kind of like a yes or a no if I can get one out of you.
Can I say yes to part of your question and explain why? Is that okay?
You can do whatever you want. I was just hoping for a yes or no.
Well, the reason that I would like to do that is because you asked about his subjective intent, and you also asked about the reasonable perception of the audience. So I don't think the subjective intent is relevant, so that's a no to that part of the question.
All right.
But to the to the audience's perception, I think it can be relevant, and here's how. I think Campbell's soup can is a very good example of this. In Campbell's soup cans, the effect on the viewer, the effect on the audience, depended on the incorporation of a very well-known commercial advertising logo. It wouldn't have worked if you...
Well, let me stop you there, and I'm sorry to interrupt again, but see, Campbell's soup seems to be an easy case, because the purpose of the use for Andy Warhol was not to sell tomato soup in the supermarket. It was to induce a reaction from a viewer in a museum or in other settings. And the difficulty of this case is that this particular image is being used, arguably, maybe, for the same purpose to identify an individual in a magazine, okay, in a commercial setting. So that the Campbell soup one seems to be a very different case, and this is a much harder case. So back to my question.
So I completely agree with you on the purpose of the use being very different in the Campbell soup can analysis, which makes it an easier case. But I was also using the Campbell soup cans as an example of why the effect on the audience would matter. And the effect of the audience in the Campbell soup can case, it would matter that you incorporated from a pre-existing commercial advertising logo, as opposed to made your own logo, made up a logo. Whereas here, if he had taken his own photograph of Prince, that wasn't necessary for the effect, which is a very different type of analysis. I hope I answered Your Honor's question.
You've done a great job. Thank you.
Yes, Jessica?
Can I just ask you about that? Because you said it wasn't necessary. But I had thought that one of the differences between these two briefs was that Ms. Blatt says it has to be necessary, and that the government says, well, necessary is a significant part of the question, but even if it's not necessary, it can satisfy factor one.
You're exactly right. That is a difference between us. I think that, and the answer in the Campbell soup can analysis is probably that it's not necessary that he needed to use the Campbell soup can, but that because maybe he could have used Cheerios, but that it was highly useful to use that type of advertising logo. I think the best example of those distinctions is in a book review, where it's not necessary to incorporate the underlying book. You can certainly imagine publishing the book review without incorporating some excerpts from the underlying work, but then you'd be telling the reader things as opposed to showing them, so it makes that far more effective to the audience.
Justice Kavanaugh?
So the exact words we use on that question in the opinion, if we were to agree with your side, will undoubtedly be the subject of a lot of debate. So I want to get it exactly right. So what are you advocating? I've heard you say necessary, essential, or highly useful. Is that the formulation?
We would say that's a great formulation, or you could say necessary or at least useful, or you could say just essential, and I think that covers it. But I think the best way to explain this is
those are going to be those are very different in some courts of appeals. So what's your best, your best answers to what the best formulation is from the perspective of the United States for the opinion, if your side wins?
If you're going for the straightforward clarity of a one-word answer, I would say essential. The reason we use
No, you can use multiple words. What's the formulation?
The reason we said necessary or at least useful, and the reason we used that formulation was because in a lot of cases, and a lot of the most straightforward fair cases, it will be necessary. And I think that's why respondent has used that word. We think that there are cases in which it is essential or highly useful, and those should also count.
I always thought necessary and essential were synonyms. If you say necessary and you say essential, that to me means the same thing, which is something different from useful or even highly useful.
We think that highly useful works too. And like I said, I think the reason that a highly useful test would work is in the book review context that I gave your honor earlier, which it's not necessary, and I think there's a lot of examples that's the case. I think using the word necessary does lead to more straightforward results in the mine run of cases.
Okay, I'm going to really pin you down again on the necessary or highly useful, or necessary or at least useful.
We would say necessary or at least useful, and the important thing is that it's an affirmative defense. So the defendant in the case is giving a justification for why their borrowing is necessary. What really separates us from petitioner is not necessary versus useful or essential. It's that we think you need that justification for borrowing, right? We think you need some reason why it was essential for you to incorporate the pre-existing work. I think the best formulation, given your considerations here, is necessary or at least useful. That's how I would phrase it, for your opinion.
Very helpful, thank you.
Justice Barrett?
So you would leave out essential?
I was deferring to Justice Kagan, who sees necessary and essential as synonyms, but I think that essential would work as well.
Okay, thank you.
Justice Jackson.
And can I just clarify, essential to incorporate the existing work in order to what? In order to achieve a purpose that's different than I just have a better idea, right? In order to achieve a purpose that transcends a changed message or meaning, right?
That's exactly right. In order to achieve a distinct purpose.
A distinct purpose.
Yes, that's exactly right.
Thank you, counsel. Rebuttal, Mr. Martinez.
Thank you, Your Honor. I want to address three things: meaning or message / purpose, indispensability, usefulness, necessity, and then the consequences of this case. With respect to meaning or message, I understood my friend Ms. Blatt to concede. She said it was absolutely true that you could consider meaning or message at factor one as part of the purpose inquiry. She said that. I took that to be a very big difference from what she said in her brief. In page 2 of her brief, she says it would be a fool's errand to conduct that analysis. And on page 22 of her brief, she says that courts are just incapable of doing this. I think that's a very significant concession, and we agree with that concession. We think that it requires a reversal in this case, or at least a vacator of the Second Circuit's ruling, because on pages 22 to 23 of the Second Circuit's analysis, I think they were unambiguously saying that courts cannot try to do this meaning or message inquiry, and then they go on to say, instead, you need to look at the degree of visual similarity. Now, I'm not sure what the government's position exactly is, whether they've made the same concession or not. As I understood the government's position with respect to purpose, they continue to hold the line that the level of generality has to be, these are two portraits of Prince, therefore they are the same purpose, which I understand to mean that if you have two different portraits of Prince conveying very different meaning or messages, it doesn't matter. In other words, they would still excommunicate meaning or message from the factor one analysis, We don't think that's right. We don't think it's consistent with the text, Campbell, Google, all the things that we've already talked about. Secondly, with respect to indispensability, I understood my friend, Ms. Blatt, again to concede that the position she took in her brief is not the right one, or at least to say she's fine with the government's much different and lower standard. She went from indispensability in the brief to usefulness here at oral argument. With respect to whether usefulness is required, a couple of things. First of all, Goldsmith herself conceded usefulness, and if you just look at page 76A of the petition appendix, the district court quoted her as conceding usefulness and even perhaps as conceding necessity. Secondly, usefulness, at least in the sense that it's been discussed here today, has not been briefed, has not been argued at any stage in the case. We heard a long colloquy on exactly what the varying different standards mean. If you thought that that was some sort of requirement, at a minimum, we would need to have a fair opportunity to satisfy that requirement once you tell us what the law is. As to what the law should be with respect to usefulness, we think the best way to look at this is it's a question of justification. And the way you should get the answer to what kind of justification is required, if you look at Judge LaValle's article at page 1111, he talks about the justification for the taking being the addition of new meaning or message. We think that's what Campbell had in mind. Essentially, you're justified in borrowing, at least under factor one to some extent, if you're doing something more than just avoiding the drudgery of coming up with something new on your own. And finally, with respect to usefulness, just on the facts, we absolutely would satisfy this, not just because she conceded it, but because of course it's useful for an artist to use an artist reference. The whole purpose of an artist reference is to make use of that because it's useful in creating the work of art, the second work of art. So of course it was useful. Goldsmith herself concedes in her brief that we needed to use a picture of Prince. And I think both the government and Goldsmith said that, hey, they could have used any old picture of Prince, and the examples they give is to point to a bunch of other copyrighted pictures of Prince that appeared in our brief at pages 16 to 17. But it can't be the case that their answer is that we should have borrowed from someone else, and then we'd be having the same case with a different photographer. I think the reality, Justice Alito, to your point, is any picture of Prince that was out there in 1984 when Warhol was creating this work, there's every reason to believe it would have been copyrighted. The copyright attaches in a photograph at the moment the photograph is taken. There's no reason to believe that there would have been any sort of non-copyrighted option. Finally, Your Honors, consequences. On consequences, it's really important to understand that the creation of the Warhol works is directly at play in this case. If you look at the requests for relief, both sides requested essentially an adjudication of who owns the copyright. That turns on whether the Warhol was acted lawfully or unlawfully at the moment of creation. We sought a declaratory judgment. We sought summary judgment as to all 16 works, not just the 2 works, orange and purple, that are at issue here. We sought a declaratory judgment as to all 16 works. We won that declaratory judgment. They appealed, and they got that victory overturned. Ms. Blatt says that she's in some other segments of the case, maybe it was at oral argument, maybe it was at briefing, she sort of like changed the relief she was seeking. It doesn't matter. We sought a declaratory judgment on all 16 works. We won that. That's in play, and the creation matters. I think the other reason the creation matters, Justice Barrett, to your question, is because it directly governs the display question when you're talking about museums. The reason a museum can display a work under Section 109 is because it was lawfully made. So the question is, at the moment it was made, was it lawful? The copyright question of who owns the copyright here turns on that. If Warhol infringed the copyright, it wasn't lawfully made. Your Honors, this case has implications beyond just Warhol. It affects all artists, and especially contemporary artists. We ask you to reverse.
Thank you, counsel. The case is submitted.
Well, okay. That was exciting. I know that I probably sound like a legal nerd when I talk about my excitement there, but a lot occurred, a lot happened. I have pages of notes here with some interesting points, and I will tell you that there's going to be a lot more analysis of this to come. For the next little bit, we're going to bring Jeff Sedlick back in, and I will pull him up here. And hey, Jeff, how are you?
Hey, it's interesting to hear the future of your profession being debated while
I know, right?
you're on
It's
mute, right?
yeah, I can only imagine, and I think that there's a lot of things that I want to touch on, and by the way, we may be waiting for another special guest here who was actually at the court. I'm going to wait to see if he can join us before I get super excited about that. But let me first say this. Oh, hold on, let me shut this off here. I still had arguments on. We don't need to listen to the next case. I've had enough questions for the moment to digest. So Jeff, let me first say, you know, we all hope when we write amicus briefs that it helps persuade the court and the justices to see alternative points of view and how this would impact the various groups that we all represent. But it is rare that a sitting justice during oral arguments will specifically quote from an amicus brief, and they quoted from your amicus brief. And so congratulations on that. And you know, I think it's important to note that, and I think I have it up here, but Jeff, talk about that for a quick second.
Sure. Well, you know, that's why we write, anyone who writes an amicus brief writes it so that hopefully it will make it through the staff that work for each of the justices and get passed up in the form of a recommended question or a comment, and it ends up with the justices, and then it ends up getting asked. There were, I don't know how many briefs submitted, but I believe at least 50 in this case. And it was great to hear them quote from me and the attorney working with me, Matthew Hirsch, about the threat that's posed to visual artists and actually all creators. But my brief focused on the threat to photographers from the prospect of anyone being able to copy our work immediately after it's created, after we put all that work and after we create our works, to allow anyone to be able to copy it and just claim that they added new meaning or message, or it's for a different purpose. When in reality, as photographers, we create works for use for all purposes. The first use is just the first use. We own our copyrights for our life plus 70 years. Our estates can then offer our works up for licensing. And so while we might initially create a work for use on a book cover, it might be also later used for fine art print sales, for trade show booths, on coffee mugs, or tattoos for that matter. So it's just wonderful to have them quote about the threat to photographers and our livelihood.
Well, getting to some of the justices questioning, you know, when you listen to Supreme Court cases, we kind of know what the parties are going to say. They've done a lot of briefing. You've seen these arguments, and as in this case, I think the first article I wrote about this case for ASMP was in 2017. I think the case started a year or two before that. And so we kind of know what the sides think, but hearing oral arguments is the first chance we get to hear what the justices are interested in learning more about. There are a few things that I wanted to bring up. I think first, holistically, as I mentioned before we listened to the argument, it is a futile task to try to read into the questions when we're thinking of what the actual result is going to be. So many times you'll listen to oral argument and you'll say, well, clearly the court is leaning in one direction or another, and the decision can come out differently. That being said, I think holistically, listening to the questions for both sides, the justices across the spectrum had some pretty pointed and direct questions for the Warhol Foundation. I wanted to bring up one or two lines of questioning that I found interesting, and I'm going to skip around a little bit here. But you know, one thing I particularly keyed in on was Justice Thomas's analogy. And Justice Thomas's analogy gets to the heart of something that I think a lot of us have mentioned, which is, let's assume that the orange prince standing alone is transformative, such that it has its own copyright. If Justice Thomas were to take that image and put it on a poster and write in words below the image, "Go Orange," and take it and sell it to his friends at Syracuse University, would the Warhol Foundation then sue Justice Thomas for copyright infringement? And I thought that's a question that gets at the heart of this issue, because it's very hard to listen to that line of questioning and not think that that the Warhol Foundation might be playing both sides in this situation, right? And of course, all the opinions I'm going to render are my own. And that ultimate line of questioning ended with what almost amounted to an admission that the Warhol Foundation would take action against such a hypothetical, because it's then infringing on a work using what they tried to distinguish as qualitative differences. But I thought that whole line of questioning was pretty important, and one of the things that may stick out. There was another question from Justice Alito, and it didn't have to do with photography. It had to do with music. And he brought up the point that, let's take a popular song, and the song is often covered. Lots of people cover the song. That each of those artists who are making covers, they necessarily likely think that they're conveying a new meaning or message. That's their point. They're imbuing their authorship, their creativity on the original. But no one would think that in those situations, the person who's covering the song wouldn't need a license. And if they didn't have a license, they would be infringing. I thought that was a particularly cogent point when we're talking if the only issue is whether the artist subjectively thinks they have new meaning or message, then necessarily all the situations where you would have music licenses, such as with a cover, would be rendered moot. One thing, and I know this is very quick hit here. I'm going to have to digest the transcript, and we'll come back and we'll do some more videos on this, of course. But one thing I wanted to bring up with you, Jeff, is something you and I have talked about offline for years now, and that is, while this case ostensibly was about factor one, I think factor four got more play here than I was anticipating, and two, I think it should have, by the way, and two, then I think all the sides were necessarily prepared for. But as you and I have discussed, factor four is pretty critical to this analysis. Let me share my screen real quick so that everyone can see what we're talking about when we talk about these factors. So if we look at four factors, the four factors are the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or value of the copyrighted work. And you heard so many references to factor one and factor four, and those are the two that are really at issue in this case. But Jeff, can you talk a little bit about why factor four is important, especially when you might only be thinking about looking at factor one?
Sure. So first of all, I think that fundamentally people tend to look at factor four as only being selling artwork in competition. And in this case, the district court looked at it that way. They said, well, Lynn Goldsmith is no Warhol, and Warhol's works sell for millions and Goldsmith's works sell for thousands, so they're just not in competition. And then the circuit court came back and said, no, the district court is wrong, and this very example in this case where Goldsmith's work competed with Warhol's work to get on the cover of that publication is an example of them competing for licensing opportunities. On the one hand, ARS, the agency for Warhol Foundation, actively licensing their works, and in fact, licensed it on 9 occasions, I believe. And then Lynn Goldsmith actively licensing her works. And Lynn Goldsmith, under copyright law, has the right to reserve an image and let it either accrue value or otherwise determine. She has the right, the exclusive right, to determine when and where and how it's going to be licensed. And there's an additional component to the fourth factor from my perspective, and that is the work that we create as photographers reflects on us. The attribution for that work, or the crediting for that work, and I'm not really talking about a photo credit per se, but the fact that we created a work and that work is associated with us has value. And when another artist creates a derivative work and it becomes associated with them and it's a copy of our work, it diverts that value, which, branding and marketing of our own works and our own style is an important component. So it's not just selling works. And I think that, here you have to balance, as you mentioned, all 4 factors. And as photographers, when we contact an alleged infringer, I don't know, the most common answer, well, this is public domain because it was on the web. And then the second most and that's wrong, by the way. And then the second most common answer is, this is fair use because I credited you, or this is fair use because I used it for a nonprofit purpose or an educational purpose. Well, look at our industry. Educational licensing of photographs might be the biggest section or sector for the licensing of photographs by photographers. Similarly, the use by the news industry of photographs is a huge sector. So merely using an image for news or educational purposes does not mean it's fair use. Somehow we went off the rails in this country where the focus of that news or of that education should be about the photograph or the photographer, not the subject matter of the photograph.
I excellently put, and I think that we don't know what the ultimate result of this case will be, but I think one thing that was made clear is that it is difficult, if not impossible, to disentangle these factors from each other, and in this case, especially factors 1 and 4. I wanted to hit on just a few other quick topics, and by the way, if you are an ASMP member, we will be doing some town halls and also some live Q&As on this in the near future. If you're not an ASMP member, we'd absolutely love to have you be an ASMP member, just like Lynn Goldsmith is. But a few things that stood out, and these are just some quotes. Justice Barrett said Warhol didn't need Goldsmith's photo. I mean, just very clearly came out and said that, which started a whole conversation, which you heard argued by Goldsmith's attorney Lisa Blatt, about the need of the person using the work to need that particular work versus another type of work. And what kept coming up was this idea of critique or commentary, right? Obviously, if I am writing as was referenced in the case today, if I'm writing a book review about a book, then I can, under fair use passages from the book to critique or have commentary on that book. So there was this idea of that you absolutely need a work or don't need a work, which leads me to something that I think hopefully I will once again thank my co-authors for the ASMP amicus brief, along with NPPA and APA, Steve Doninger, Mickey, and Alicia Calzada. And we have at the end of our summary something that I heard echoed in the arguments from the justices today. I'll pull this up as well. Let's see. And this crosses a page, so bear with me. But we wrote, this court should reject AWF's efforts to divorce fair use analysis from the use at issue, and instead put undue weight, if not sole focus, on whether a derivative arguably has new meaning or message. AWF would turn copyright law on its head by making fair use the rule rather than the exception, and stifle the creative activity of authors and inventors by undermining the incentives to invest in and create truly original work. What's the use indeed? And the idea there is that, and what I heard echoed so many times here, is that it's important to take into account what the use is. You know, is the use what we're looking at here, which is licensing a photo of a celebrity, licensing an image of a celebrity for a magazine cover, versus all the other various uses that there could be. And I think the court did more than it's done in previous cases so far in its questioning, making a distinction between saying things are categorically fair use or not fair use, and asking for more information about what the particular use is. Jeff, did you have any thoughts on that?
I do. And, you know, the notion that's kind of put forth by the Warhol Foundation and their amici is that the sky is falling, right? Like if the court were to rule in Lynn Goldsmith's favor, no artist could ever create a derivative work of a photograph. But that's just not the case. And you have to look back to what actually happened here. Warhol needed a photograph to reference, one or more photographs. His client reached out to Lynn Goldsmith's agency, requested the right to create a derivative work, was granted a license for artist reference. Lynn Goldsmith was paid, and Andy Warhol then made the illustration. And this is how it has worked in the arts for decades. This is nothing new. This happened back in the 80s, and it has been going on all the way through the history of copyright, is this creation of new works, at the very least approaching the original artist, whether that's a painter, a photographer, an author, a musician who created the original work, and requesting permission, not in order to criticize or review or comment on that work, but in order to create a new work, even if it's different. There's a huge difference between inspiration and replication. And what we saw here, and some of the judges' questions were kind of revealing, they referenced Lynn Goldsmith's photograph as a mere depiction of Prince. Well, as photographers, we're not, or most of us are not, laying our subjects on a scanner and pressing go and just letting it replicate their likeness. We are making thousands of creative choices, even in creating what appears to be a simple photograph. In fact, the more choices we make, the more skill and subjective creativity we exercise, and the less that you can tell that we did that, the more skilled we were, the more successful we are. So our photographs are, we are basically creating our interpretation of that person's likeness through not only our lighting, but where we place the camera, the lens we choose to flatten out the person's shape, the distance between the subject and whatever the background is, juxtapositions of things between the camera and the subject, our direction to the subject for posing, all of those choices, light and shade and everything else, including our interaction with the subject when it comes to portraiture or photographs of people. Those photographs that we create reflect our relationship at that moment with that subject. And that's why every portrait by every photographer of the same person looks different because it comes from within. It comes from our ability to create and exercise our free speech, our subjective creative decisions to create our works. And this applies not only to portrait photography or studio photography like Lynn Goldsmith or I might do, but photojournalists also exercise all of those same things, but they do so in a millisecond. They position themselves to be able to capture an image. They've made their choices as to lens and perspective and where they're going to place the camera. Their entire life's experience is focused on being able to capture a moment that tells the story. And just because they do that faster than a portrait photographer like Lynn Goldsmith or myself doesn't mean that they've exercised less creative, subjective decision-making.
Jeff, after listening, being so involved in this case for so long, and I'm sorry, I'm trying to see if we can work in our other guests here, so give me just a minute. But Jeff, can you maybe just give me your overall impressions of what you heard, or one or two takeaways that you think that you think the viewers should keep in mind?
I think focusing on this, what they called the conflation of purpose and meaning and message, is really what this is all about. This is what the question is that's before the Supreme Court. Maybe they'll deal with other things and clarify those. Hopefully they will when they issue their ruling. But I think that's the core here. And in the statute, purpose is mentioned only as to the type of use of the work. In other words, is it for commentary? Is it for parody? Is it, is it for reporting? Those types of uses are the purpose. And somewhere along the way, and it has a great deal to do with misinterpretation, I think, of Judge LaValle's writings, we got off onto this tangent where meaning and message, like changing some small aspect of an image, can kind of sidestep copyright law, which removes the incentive for us to create. I was concerned by some of the judge's comments as to the photograph just being a mere depiction of the work versus Andy Warhol adding some color and darkening one eye and a disembodied head or what have you. What Andy Warhol did was to copy the photograph, take a photograph of the photograph, make a silk screen. And I'm not saying that it's not a piece of art. In fact, I love those Warhol works. However, he did exceed the license, and now they are competing. And one of the issues that wasn't really discussed was the statute of limitations. And I would like my fellow photographers to understand that, in order to bring a lawsuit or to have claims in a lawsuit or counterclaims, you have to do so within the statute of limitations, which is 3 years from the date that the infringement started, or where you would have or could have reasonably known that the infringement was taking place. And so the actual creation of the works so many decades ago, Lynn Goldsmith could not really make a claim about that. And so they rightfully focused on the more recent use on the cover of that tribute publication.
Right, absolutely. So here is what I want to do. Unfortunately, our other guest, Mickey Ostraker from National Press Photographers Association, isn't going to be able to call in. He was there at the court today at the arguments. I am coordinating with him, and he and I will do a video tonight or early in the morning, so you can get his firsthand impressions on what it was like to be at the court today. I know there is a lot of information that we talked about, a lot of things that happened during the oral argument. I'm excited to go and read the transcript. We'll do it live again tomorrow. I'm not sure exactly what time. I have to check with Mickey, but I'll make an announcement so that we'll be back here on YouTube and Facebook and LinkedIn and Twitter and all the places we are. I want to thank all of you for staying with us, so many of you for 4 hours or so. And I think this is a critically important case, something that's going to have ramifications on every copyright owner and every copyright user moving forward, certainly in the visual arts and certainly in photography. We are witnessing something that these things will sneak up on you. But as I mentioned, the last major fair use case that dealt with this was more than 25 years ago. And so this is why this is so important. This is going to create some law one way or the other, and we're going to have to keep a close eye on it. For now, I want to thank you, Jeff, for all your expert analysis and experiences today, and your commentary, and for getting up early on the West Coast there. So thank you for joining us. Any final thoughts from you?
I think so. I'd like to close with words from Andy Warhol that I just pulled up from his book, The Philosophy of Andy Warhol, From A to B and Back Again. Business art is the step that comes after art. I started as a commercial artist and I want to finish as a business artist. After I did the thing called art, or whatever it's called, I went into business art. I wanted to be an art businessman or a business artist. Being good in the business is the most fascinating kind of art. During the hippie era, people put down the idea of business. They'd say money is bad and working is bad, but making money is art, and working is art, and good business is the best art. And then he wrote about using other people's work. You're recycling work and recycling people, and you're running your business as a byproduct of other businesses, of other directly competitive businesses, as a matter of fact. So that's a very economical procedure.
I think that's a great place to end, and thank you again. Certainly subscribe to ASMP's YouTube channel. That way you'll know when we start doing live streams and other broadcasts. I don't think we've ever done a live broadcast, at least I haven't, for ASMP, and so thank you for being part of this inaugural one. And look for a new broadcast tomorrow with some people who are actually there at the court. I talked with Lynn yesterday, and was informed, as I expected, that she won't be able to talk about the case. Her lawyers can't talk about the case till a decision is reached. But know that ASMP has long been supportive of Lynn and her team here. This is an important case, and I appreciate everyone for viewing. Everyone have a great day, and we will talk soon. Thank you.